Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring
relevant.
the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po, he's verbous Latino.
Is that correct?
I didn't ask you to interrupt me.
That's literally not true.
Oh, for Trump's sake.
Good morning, good morning. No, where are we? There we go. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Oh my goodness, what a day. Are you guys ready? Are you guys ready for what we are about to receive? It's gonna be a good one. Welcome one and all. Especially welcome to Mrs. McGuire, I'm trying to say. Mouth's still waking up. There we go. Mrs. McGuire, you're first in chat today. First in chat is an honor. It's a privilege. It's a pleasure for us because there's a punishment for you. Everything IP related worldwide is your responsibility. This goes on your permanent record. You're responsible for the internet because you broke the stillness, the silence, the peace of the morning. Good riddance, I say. We'll get this working later. I'm sorry, we're still working on fine-tuning I want it to work so that you guys can control it and switch it back between subscribers and likes on command. So we're still working on that. Spent some time doing that yesterday, but now it's not plugged in quite yet. Oh my goodness, I'm not sure if I'm ready for today. Really, I'm not. So many references to, I'd say there's lots of categories, but really there's just one category. You could call it a scategory if you want. A scatologic reference. It's gonna be a poop show. But before that, consider yourself warned.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. I'm sorry, I was up till like 2:30. I've got all. Thank you. You're lying, but I appreciate the thumbs up. Almost got 3 unanimous thumbs down. It's hump day. I'm sorry. It's. No, everyone's like, boo. I don't even have any support here in my own household. We are halfway through the work week. We've made it all the way to Wednesday. I was up a little bit late, picking up. I can't say this loud because she might hear, and I don't know if she knows. Picking up my future daughter-in-law from the airport, and don't tell anyone. In case I think it's still a secret from her. I know her parents don't know. So, anyway, there was that. Just a lot of driving, and I think I might be in a big trouble right now. I'm sorry. You made it just in time for the worst hump day yell ever. Consider yourself blessed. Really, honestly, 2 out of 10, 3 out of 10. I'm going to take that. We didn't get home till like 2:30, 3 o'clock in the morning. And by the way, the whole time we're driving, it's like, warning, scattered tornadoes ahead. Warning, watch for flying debris. Warning, flood zone. Slow down. Don't drive through standing water. This is just like the commute to the airport. It was nuts. It was absolutely nuts. And the best lightning show nature has ever provided in North Carolina happened last night as well. All right. That being said, 1 out of 10, little Miss Princess me. I have done better, but I will not do better today. Are we still doing this? The complete works of Edgar Allan Poe? Yes, that's fantastic. I like that one. We have to celebrate some birthdays, and then we're going to go first to Judge Dad's court because he's having a day. It's a hump day for him for sure, and then we're going to be going back to the poo, the poopy case. Red Pan brings the birthdays today. Thank you, Red Pan, and all our wonderful mods. If you can give them you can say thank you, you're amazing, and chat to the mods. But what they really want is just y'all be nice. Y'all be nice. Don't make them work harder than they need to. Every day. This is their sole wish. I think they would rather not be mentioned than have to time people out and chase down little squabbles and stuff. But I'll mention them. They're fantastic. Thank you very much. Happy Wednesday, mods. Let's see. Buffer. Happy birthday to a Tan21 at or a tat. Are these all the same person? They seem remarkably similar. And Tequila Mockingbird, one of my favorite usernames. Little Gregory reference there, right? Can't remember Gregory's last name. Peck? Is it Peck? I think it's Peck that wrote Tequila Mockingbird. All right, let's sing Happy Birthday. I've saved my voice for this because I didn't use it up in the scream. So wherever you are, if you're able and it's legal, take a deep breath, shoulders back, stand up. I have to do this in order. Now I can't remember what it says. Stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Happy birthday to you. Happy birthday to you. Happy birthday, dear Tan21, and Tequila Mockingbird. Happy birthday to you. Okay, it's your birthday. It's your birthday. Go short. All right, to everyone who has a birthday today, happy birthday. I realize there are a million places you could be and a billion people you could be with. But you chose to be here with us. The privilege, pleasure, the honor, the joy, that's ours. Hope we can turn that joy right back to you, make your day just a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village, and Waffle House, McDonald's, Having That Left House, Sandwich Grill, Bob Evans, and Cracker Barrel. There we go. That's it. Happy birthday. Now the dancers are going to do their thing. The pancakes are coming up hot off the grill. Get them while they're hot. Appreciate y'all starting the party off right. We had waffles at our house. Everyone else had waffles. I made myself an omelet. Because rank has its privileges, folks. And I wanted an omelet. And so I told Mrs. R.A. that I want an omelet. And she said, you can have one then, because what you want, you can get. And I waited. And then I understand she said, you can get. And so I made myself an omelet. That's how it went down this morning. I don't tell Mrs. R.A. anything. I ask politely if I want something. Then I have a chance. All right, happy birthday. I'm seeing these buffers. Drum solo. Drum your heart out, because maybe if we do well, the video will work. All right. Please work. We really want this video. Don't mess it up for us. Okay, let's go here. Let's see if this works. Judge Dad disappeared. Everyone warned me. I'm like, no, I've got it on pause. It'll work. And suddenly all his videos just gone. What happened? Mr. Boyd showed up. We had Mr. Boyd in the courtroom for his last chance ever. What? Somebody has to spoil it for us now. I thought having it on pause. A lot of times, this is a little fun fact. A lot of times, if a content creator unlists their videos, sometimes you can still play it if you were playing it when it all started. Judge Dad just zoinked his whole channel. Why? Judge McNally. Judge Brook Valley. That's not what I said, but... Well, that's why we started early. Somebody has to tell us what happened with Mr. Boyd, because I don't know. They were using words like debris and foliage too. Foliage, sorry. No, this is a thing judges do periodically. What happens is they go to Thurston County courts. Okay, we'll do this really quickly. What happens is they get a complaint from somebody, right? Somebody's like, I'm going to sue you because you didn't have my permission to put... And they're like, whatever, we're just going to delete it. And then it sort of mitigates the results. Midstream? Was somebody like watching up to the minute? Did like they show some evidence that's not YouTube friendly? I mean, what was it? Was it a phone number that went out? Was it? The Wayback Machine? I don't think the Wayback Machine can find this one. Yeah, video's unavailable. Boom. It's gone. The video has been removed by the uploader. I was, and no, it wasn't anything serious. Maybe someone just got explosive diarrhea, clicked the wrong button. It's like they privatized the channel instead of deleting old stuff. They just clicked everything and deleted it. Well, I wonder if any of their locals are going to call the court and say, hey, why isn't the court streaming anymore? What happened? Okay, we were going to Thurston County. Hang on. Thurston County Court 3. Try this again. Thurston County Courts. We're going to 3, right? Which one's 3? Hold, please. Oh, this is 3. Yesterday, which one are we going to? Kathy, just in time. It's about to hit the fan. Not this, but everything that's going down today is going to hit the fan. Let's see. IC calendar courtroom 3. Do we have a timestamp, Georgia fan? Josh? Why did that just happen? I pushed the wrong button. That's why. Cut. That's not it. Let's go to 7. Cut.
Good afternoon, Your Honor.
Okay. Pause for a second. Before we play this, let me just say, I was watching this morning. I was watching this. I was watching Cat Not Williams. This Can a Password Be a Crime? Shout out to Cat. My wife gets to watch her more than I do because I'm working, but this video just reached out and grabbed me. I'm a sucker for for rights, protection of your rights, right? This any case that involves unlawful seizure and warrantless searches and things like that. Can't wait to follow up on this one. This is a very interesting case. It's Mr. Tunick, I think it is. So we'll see. 1 hour 53 minutes. Thank you, Josh. Let's jump to 1 hour 53 minutes. Thurston won't let us down for sure, right? 153 would put us about right here. Well, they saved it till the end. It must be a good one. Judge,
what I'm missing is
nope.
Medication.
ADHD. Nope, definitely not.
Okay, he's smiling
All right,
already.
could you raise your right hand?
Hey.
Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes.
Do we need to back up and see what she doesn't, what she has other than ADHD? Because that's not it.
We'll see if you can get it done.
Okay. Thank you very much.
That's a nice
Alrighty.
painting.
Have a good afternoon.
Crashing
Thank you.
ocean waves.
Yep. Are you Ms. Harp or Ms. Wachter?
Ms. Wachter.
On up.
Sorry about my phone. It's my son's meds timer alarm, and I don't know how to not make that ring when it's on silent.
Did he take his meds? Let's get to the bottom
I texted
line.
my mom and made sure. Yes.
Okay. Here, have some.
Oh, okay.
Good.
Okay, so her phone alarm went off for her son's meds timer.
What I'm missing is
Nope.
medication.
ADHD. Nope, definitely not.
Okay, that makes more sense. We
All right,
needed
could you
that.
raise your right hand?
Hey.
Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes.
All right, Ms. Foster is a neighbor.
Mm-hmm. Yes. A direct neighbor. Sorry for
Okay.
the vulgar language in there, but I figured it
I
was.
have a different question, which
Oh.
is she's either going to turn 100 years old this fall, or she has yet to be born. You have the date of birth of 11/24/26.
Oh my gosh.
She's really young, Judge.
Do you want me to grab the actual birth date? I have a screenshot on my phone.
Yeah, let's get
Sorry,
that
I
correct.
tried to get everything right. $1983.
Okay.
That's different.
Sorry about that.
If you want to insult her, you can tell her what you wrote down.
I don't think she's here, Judge. I'd like to be born, find out you get served with papers same day, before you get your birth certificate. You've been served. Happy birthday.
All right, so most of Ms. Foster's vitriol and diatribe seem directed at her partner or her husband.
Yeah, there's a lot of issues that go on over there. It hasn't been till recently, and that's why I tried to name the most recent things that now it's being directed more towards us. I've always tried to get along with them because of what goes on over there. And then things just seem to be progressing and directed at, they've always gone towards her other neighbor on the other side of her. But now it's come my way.
Okay, so she said she'd burned down your house at the end of June, and that was yelled at you or your son?
It was yelled, screamed on her property at us in my son's room.
Okay. She knew you were listening?
Oh yeah, she likes to let it be known that she's talking to us over there, but she did it. So a lot of times things will happen on one day and then like it'll be quiet for a couple days, but she the next morning started screaming again. And so that's why I was saying that it's just gotten progressively worse and it's not getting better, like for even just a short time.
Okay, so besides her threatening to burn down your house, what other threats has she made to you?
Those are the only 2 times that she has actually threatened me, my children, my home directly. She said she was going to blow up the town because she got her water shut off a few months ago, things like that, but not me directly. So I've had to call the cops many of times over there. Lots. She had a guest recently that was peeing on my garbage cans who was drunk and had his pants down while I had my 8-year-old in the car. And so there's been a lot of, it's been an interesting 3 years.
And you live out in Dakota?
Yes. The rent was cheap. What can I say?
I ride my bike through there a lot.
Do you?
Tono, so.
Oh, yeah. My little guy, I don't know if you ever see him. He's on a little 50 dirt bike in America colored riding gear. But
he's not the one who tried to run me off the road, is he?
He's 8. I don't think so. Okay.
Nobody tried to run me off.
Oh, okay. And I'm always watching, so.
So, are you 2 immediate neighbors?
Yes.
And who serves Dakota? Is that the sheriff?
It's the sheriff, yes, who's very familiar with their home. I'm sure you read it, but it's all over stealing kittens from her home. She has 27 of them, and they're all so sick. One actually just had to have its eye removed because it was neglected so badly. Yeah.
Do you work?
Yes, I work 2 jobs.
Is your workplace ever a place that she comes to, or is it just your home?
So I work primarily from home with 1 job, but no, it's just my home. I just want to make sure that my 16-year-old son, when he's going in and out of the home, and myself, I mean, I'm a big girl, but like it's just gotten to the point where I pride myself in being a good mom, and this isn't a good example of a safe place for my children. So
by this order, just so you're clear, I am going to issue a temporary protection order, but I can't quiet her down.
I know.
I can tell her she can't contact you or your children.
Mm-hmm.
Doesn't mean she can't scream at her husband or the neighbors.
I know.
Or anything else.
Yeah, I appreciate it. I just call the cops every time I hear them fighting and do what I can, but they just don't really care about who they're affecting, that I have children in my home and things like that. So my 16-year-old who was 13 3 years ago learned what chlamydia was the first month we lived there, because she was screaming that he cheated on her and gave her chlamydia. So it's been great.
I won't comment on that.
Mm-hmm.
Okay, I've signed a protection order directing Ms. Foster to not reach out to you or your family.
Okay.
Or to come within 10 feet of you or your family or your property.
Thank you.
This order will be heard on the 10th of August. Ms. Foster is entitled to be present.
Okay.
I've directed the sheriff's office to serve her. And what you're going to want to do, since you're here in person, is wait out in the lobby. Somebody from the civil office will come and get you what's called the service packet.
Okay.
And you'll need to get that to the sheriff's office for service. They'll charge you for serving Ms. Foster. And you'll need to get it to them and then stay in touch with them to help them give them any information they need to get her served.
Okay.
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 And we'll see you either in person or on Zoom on the 10th of August.
Okay. And is all the information on what I need to do, like the sheriff's office, they're going to give me that?
You just have a seat out in the lobby and somebody from the civil office will come and
okay.
with you.
Okay. All right. Thank you so much.
You're welcome. Thank you. Caitlin Harp. Yeah. Thanks. Hey, Shauna, Gabby.
Oh my goodness. Oh my goodness. It all hit the fan at the same time. We're just left to entertain ourselves. Let's see. Bit of a bummer on Judge Dad. I'm sort of watching to see if his channel will come back and bring us anything. The neighbor yelling at the top of her lungs, "I'm going to burn your house down." This is your sign to move, honestly. Point. Oh, Judge DeSanto's live. What is she doing this morning? Hold on.
To establish the factual basis, Your Honor, I believe the court will find sufficient facts to support the plea.
She did not go live
sir,
yesterday.
please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, you heard the plea that your attorney placed on the record, correct?
Yes.
As to the charge of larceny on case number 221922, how do you plead?
No copies.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand, sir,
What do you understand?
how the court treats a no contest plea.
Yes.
You understand as well, sir, that by entering into this plea, you'll be waiving some of the rights you've reviewed with your attorney.
Yes.
You understand as well, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, I do.
Is that a
Knowing
question,
all of
Judge?
that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Did you have a new case here just a couple months ago?
I missed it.
No. Okay. All right.
We stipulate to the entry of the police report, Your Honor, establish the factual basis.
Any immigration issues?
No.
All right. Nobody's promised you anything, threatened you, or coerced you in any way for you to enter into your plea?
No.
All right. Let's review the report here in this moment.
Was a business call, but not this business. Different business. Did I miss something incredibly spicy?
All right. The court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the charge of larceny. Are you asking for immediate sentencing counsel? Or, well, let me double check here because it seems as though
somebody.
All the property was returned to her.
it does appear as though the property was returned. However, she is still afforded the right to address the court under the Crime Victims' Rights Act, because even though the property was returned, so you don't know to the extent that how your actions impacted somebody, right? Because at that point, there's a big trust issue.
Yes.
So the court will continue bond and conditions. Oh, wait, is there a bond even?
It was. I don't know if it's.
Well, no. I'd ordered a $5,000 10% bond.
I paid $1,000. Yes.
Oh, yes, it's over on the other case.
Are those bonds still viable, Your Honor?
Yes, it was from May. That's why. So that's what showed up on the new, on the criminal history. Yeah.
Were those bonds in your name, sir? Yeah. I was. Famous today.
So we'll transfer the bond on the matter that's being dismissed to 221922. You do have a $50 warrant fee in the matter that's being dismissed as well.
Yeah, I bet so.
So if you test right now, what's in your system?
Nothing.
Oh.
Nothing at all.
I think it's neighbor. Pretty good. Have a long.
Good. How are you feeling?
Good. Right.
Okay, I'm going to have you go over to probation and somebody will be with you shortly, sir.
Okay. We'll see you. And thank you, Your Honor.
Have a good day.
All right, Judge Stevens has started his day. We're not yet to court. The court we're following for day 3. It's going to begin shortly.
All right, let's go on the record. Matter of the City of Wyandotte versus Amy Scott. 26743.
Yeah, I think they need a restraining
Good morning, Judge. Advocate, and have Ms. Scott, State Court Interest.
Amy Scott.
Can you speak up, please?
Amy Scott.
All right. And good morning. Today is the date scheduled for the arraignment pretrial in this matter. Counsel, as to the
Just for arraignment purposes, we'll stand mute here.
court will waive the formal reading and to plead not guilty for purposes of the arraignment. And as to the pretrial counsel.
You're asking for an adjournment for discovery.
Whatever happened with the case yesterday?
Discovery order.
Judge
And we will
DeSanto.
adjourn this matter for discovery.
Where the guy turned his guns and got more trouble. That was the case. That was this judge. She did not go live yesterday, even though that was the day they were supposed to do the hearing. So she just kept it quiet.
September 30th at 10:15 a.m. Okay, and so counsel as to bond.
Judge, we're asking for a personal bond. Ms. Scott is a lifelong resident of Down River area. She is married. She has 2 children that are 14 and 16. She had no prior criminal history. I was here today, Judge, and she's eager to resolve this matter.
All right, so ma'am, if you were to test right now, what is in your system?
Nothing.
And where do you work?
Pure psychiatry and wine vest.
She's a
Have you ever
psychiatrist.
failed to appear in court for any reason? Are you on bond in any other jurisdiction?
No.
All right, the court's going to order a $5,000 personal bond. You are not to possess or consume any alcohol or drugs unless prescribed. Counsel, you get a copy of your bond, you'll get a copy of your discovery order, ma'am, you'll get a copy of your bond conditions, and then we'll see you back September 30th.
Thank you.
Thank you, have a good day. Let's go off the record from.
Oh.
Okay.
Okay, let's jump down to Judge Stevens, see how he's doing this morning before court begins.
Position was that from the beginning, this man could have been treated with a second-degree felony because of his prior convictions. He does not seem to get exactly like what they said here, the concept of not drinking and driving. The 3 prior DWIs he had were separate dates. They end up with revocations resulting in right at the same time because he didn't successfully complete his probations. But the end result is he's drinking again, and that's 8 months after he's sentenced to time on this issue. What's really a glaring thing in this report, from my opinion, as to why he should be sent to safety, comes on page...
On this offense, how long were you out of custody before you committed this new offense?
Can't be more than 8 months, Judge.
Is that what everybody thinks that?
Maybe 8 months.
I have no idea how long he actually served on that 120-day sentence. So I'm going to give him the benefit of the doubt, say 8 months. When he gets to the going to do the substance abuse evaluation.
That's not 120 days. That's 4 months.
I'm talking about between the sentence date and this new offense date from his priors. How
much time were you in custody the last time you were disciplined for DWI? Mm-hmm. Okay.
Mm-hmm.
So when we look at page 4 and the substance abuse evaluation that's done, the lady that conducted this, Ms. Posey, noted that he underreported his consumption and mood-altering substances. When she went to perform a urinalysis, he claimed he was unable to provide a sample. Miraculously, when he showed up for his PSI interview a week later, he's ready to do a test. To me, I treat that as a failure. I'm not even asking that you test him today because he shows up prepared just like he did on June 10th. He needs structured help. And that's the whole reason why I was willing to give him probation with safety. I understand what they're suggesting as far as JCDI and the structured the stair step there. And I would agree with that if someone didn't have his history. But with his history and these facts, I would feel safer for Jefferson County and our community that he doesn't leave this courtroom. He goes from here into custody and goes into safety.
Okay, from Alec.
Yes, Judge. Regarding the June 3rd and June 10th instance, he had showed up on June 3rd and told Ms. Posey that morning, the first thing, that he could not use the restroom at that time. Instead of having him wait on June 3rd at the end of this evaluation, she told him he needed to come back on June 10th to do this. So he was prepared to do this on June 10th. Also, Mr. Jefferson has been employed at the port and has been taking
there's a lot to lose here.
His job was finished, and so he has to switches to new jobs once the project is complete. And during that time, he was being drug tested. And so he has been passing his drug tests while he's been out on bond for this case. And so he's been clean. And I think this June 3rd instance was a misunderstanding. I wouldn't say it was necessarily bad faith by Mr. Jefferson to hide the fact that he wasn't going to be unable to pass a drug test. That's not the condition now. Back then, it's not the condition today. He would pass a drug test today. You would like him to take a drug test. I think JCDI would be most beneficial for him. He has 3 kids and he supports them right now. No other source of income would provide this family for the time that he's in safety.
Okay. All right. I'm willing to go along with the probation officer's recommendation on JCDI. But you got another problem with me, is you don't commit subsequent crimes and don't pay a price. The last time you did this, you got 120 days in jail. This time you're going to get 180 days. Each time you commit a crime like this, it's going to be more serious. A condition of probation, it will include 180 days in the county jail. Then when you leave there, then you go do JCDI. But you don't commit the same wrong act and not pay a higher price. But putting aside everybody else on the road who's at risk, my goodness, you have responsibilities at home. You're supposed to be a role model, set an example. But you know,
judge is letting him have it.
That committing crimes subject you to confinement. And how's that working out for the family unit?
Guess that was rhetorical. So he's on bond for a DUI, picks up another DUI.
This is the event on May 17th of 25, huh?
Yes, sir.
Okay. And you're arrested at 1:05, being over double the limit. Right?
0.17.
At 1:05 a.m., you're intoxicated? Why aren't you at home with the family that you're so worried and concerned about? You're drunk, driving a third DWI, and the family now you're worried about was at home waiting on you. Can you explain that? If they're so important in your life, why aren't they ahead of your own drunkenness in importance? And the other people who have to share the roadway with you. There's the problem right there. You got to quit being selfish and putting your life ahead of others. And then when you come before the court on this, the first thing you want to do is, I've got children at home that I'm responsible for. Yeah, you are. But this isn't a way at 1 o'clock in the morning on a third DWI. That's no way to, you got to show responsibility, not talk about it, nor use them as a defensive mechanism to prevent you from being held accountable. All right. So you're sentenced to 10 years in prison. That's suspended for 10 years, fined $1,000. You must serve 180 days in the county jail. Then you will complete the JCDI programs. Among other things, there will be other terms and conditions of probation that the probation office will go over with you. I have them in here, right?
I believe so, yes.
This is the court we're going to be in today for the crappy trial, the poop trial, and should resolve today. Jury trial, so we looks like Judge Stevens is just finishing up his morning docket before court begins. Within about 15 minutes.
There's the problem.
$180.
I can pull this white out faster than Billy the Kid could draw his gun. I use it so much.
Is he blowing on it? Is he using like the liquid whiteout? I thought that had gone extinct.
Is this? What is this one? Do I sign that? JCDI. Okay. All right. You understand what has happened today, Mr. Jefferson?
Yes, sir.
All right. Good luck to you. I see how you run out of it. Look, I got children. I got grandchildren. I can't imagine hurting them. Okay? And that's what's happening when you're in jail. But you decided that what you wanted to do was more important. That's fixable. You say you love them, show it. And it makes you a better person in life. All right. That is all. Good luck to you, sir. Here. Anything else? We're in recess. Let's get ready for trial. Thank you.
Thank you. The judge's sing-song voice. When he says get ready for trial, he says, bring me the TP. Bring us the TP. We're going to need it. It's getting deep in here. Somebody start the fans. Start the fans because it's about to go. It's about to go down. I'm not sure I'm ready for this one today. It's just been wild. Let's pop into Judge Middleton. Oh, Judge Middleton is wandering around. Oh, he's back. This is the echo chamber court. We just hear lots of echoes here. I'm bringing Lysol wipes, says Mrs. McGuire. Thank you. Appreciate that. Let's get ready for some crap. Aunt Mimi, welcome. Fun fact for y'all: this wonderful crappy case has caused enough people to unsubscribe that we, in the near future, assuming that the trend reverses itself, will be able to celebrate 73,000 subscribers again. we lost a few on this one. We're 3 short right now. We're 3 short.
I have 2 1030s, and Nate, yours is an 11.
It is.
I don't know if the
wanted to get here early to get.
Well, I appreciate it. All right, we're back after kind of a bumpy ride for Raymond's this morning. To our usual viewers, I'll let this run for just a moment. I see Mr. Guthrie is outside. He's not set till 11. Mr. Lowry is not here. Which case are you here on?
Lowry.
Okay. Is he here?
Yes. He's in custody.
Oh, he's in custody. On the new stuff?
Yes.
Oh, okay. Well, why don't we go ahead and bring him in? These are 3 weird 257, 327s, 26s. But he had I didn't realize he was in jail. I'll have to check that. It just said pending further action.
Mm-hmm.
Okay, we're pending further action.
That's the crappy.
Good morning, San Francisco, where it's 7:30. Good morning, Long Island, where it's 10:30.
Here we go. Let's go to this one. I just wanted to see Judge Stevens here, as he brought out his briefcase. He's just getting set for the days to get set for trial. Judge Middleton's just welcoming people. Look, what does he have here? It's a photograph he's sharing. It looks laminated. Can you hold it up so we can see? A little higher. That's nice. What is that? It's not an X-ray. Does anybody recognize what that is? Looks like it was drawn on the back of a clipboard, whatever it is. Oh, right there. Judge, if you could tell us, you could turn the mic on. We'd love to share in this moment with you. Oh, that's beautiful. Nice. Thank you. It's the award he got. It's the award he got from President Clinton for putting that guy in jail for 18 years for a crime he didn't commit. Is that the one he's talking about? Bailiff doing the back stretch. Trying to see if we have anything else we can pop in on. about a little Mr. Aguirre? What do you think?
Presentation.
Oh, sorry. Still here. Mr. Aguirre, you're in my spot.
One of the allegations is she's failed to pay her costs, fines, restitution, etc. But it's also alleged she failed to report to probation 1, 2, 3, 4, 5, 6, 7 times.
That's one more than 6.
And to refrain from drug and alcohol use.
Excuse me, ma'am.
Yes.
I showed up to every appointment. It was just rescheduled.
7 times?
Well, the allegation is that you failed to report to probation as required June 11th of 25, August 5th of 25, September 4th of 25, November 12th of 25, January 9th of 26, May 5th of 26, and May 14th of 26. That's the allegation.
I'm sure they just.
And Your Honor,
but I have text messages showing that all of those were
well,
rescheduled.
we're not going to have the hearing. We're not going to have the hearing right now. And she is entitled to attorney if we're going to address revoking her probation. What I would suggest that we do is just set both of these on the same day. What is your response to that, Mr. Regier?
Your Honor, for purposes of the record, the state would have concerns of just addressing the request for revocation of probation, given that she does have court-appointed counsel for purposes of that, at least. If the court is inclined to continue this matter, both the pro se motion to the same date as the request for revocation of probation is currently set before this court on August 17th, the state would not oppose that.
All right, so is there any way we can do that any sooner than August, what was it, 17th?
August 17th appears to be the date previously ordered at the hearing before District Judge Satterfield, Your Honor.
Okay. Is that a Monday?
It would appear so, Your Honor, in approximately 2 to 3 weeks' time.
All right. Miss Cowan, have you talked to Mr. Patterson about the warrant to show cause why your probation should not be revoked?
I have not yet.
You realize that you're looking at losing your probation and going to jail. Do you understand that?
I do now. I will call him today.
All right. All right. Well, that was going to be my direction, is to send you over to Mr. Patterson or to call him. Do you have his number?
Yes, ma'am.
8675309.
Be sure and call him because you've got a lot at stake here. Primarily your liberty. And I'm going to accept your motion to reduce this money owed. I'm going to set that over for that same date and talk to Mr. Patterson. Let him know you filed that motion to reduce that on your own and see how he wants to proceed with that.
Okay.
All right.
Good luck, ma'am.
Mr. Bauer, anything you want her to do between now and then? Any special direction?
If she would report, she was told when she was arrested she needed to contact me to schedule another report date, and the only thing I heard from her was, there's a warrant still out for me that's been taken care of. Can you make sure that's not out? She has not reported as she was told to.
I wasn't told. I was told that my next report date or whatever was on July 29th today at court.
That's not correct.
All right, Mr. Bauer, we'll address that at the next hearing, but if you'd make sure that that is not overlooked. I want to readdress that at the next hearing. Could you make sure we do?
I'm sure he will.
That was Judge Satterfield apparently that told her to do that.
I told her. She came and reported to me and was taken into custody, and I told her at our meeting to contact me so we could get her reporting going, continue her reporting, and she has not contacted me to schedule her next meeting.
You didn't schedule one when I called you.
Stop.
Oh, sorry.
He is your probation officer, not your sibling that you can get in an argument with, and so he wins every argument. Well, your attorney can tell you need to show him respect, and you need to follow his advice because he's here to help you succeed. And if you don't do what he says, you're probably not going to succeed. Okay, but you call Mr. Patterson as soon as this hearing is over. And Mr. Bauer, do you want to tell her a specific time to report? Or just have her call and report?
If she can call me this afternoon at 2:00.
You've got a 2:00 telephone appointment today with Mr. Bauer. Do you need his phone number?
No, ma'am, I have it.
Okay, very good. And what are we doing about bond here?
Your Honor, while it would always be the state's preference for addressing these types of matters, at least insofar as there are matters to which the defendant is entitled to court-appointed counsel and there does appear to be a $1,000 bond. It looks to be professional surety by the state's records. If the court is continuing the same, the state would inquire if the court wishes to order as a condition of bond that the defendant appear in person for the next hearing, given the procedural history of this case at present.
Not only procedural history, but local court rule is that you will appear in person, Ms. Cowan, on this type of matter. So you need to be here in person at the Butler County Courthouse for your warrant to show cause and your self-motion, August 17th, 9 a.m. I think actually Mr. Patterson likes you to be here at 8 a.m. So I'm going to order that you be here at 8 a.m. unless he tells you that 9 o'clock is acceptable. But I'm continuing this at your request. I'm continuing the bond with all existing conditions that are written on the bond and the added conditions that you go over to Mr. Patterson's office or call him as soon as this hearing is over, and that you contact Mr. Bauer at, you said 2 p.m. today, sir?
Yes, Your Honor.
That's a condition of your bond now. You got to make that call.
If you fail to comply with those orders, it could result in a bond revocation and staying in jail until this is all resolved. If there's nothing further,
Yes,
we'll be in recess. Ms. Cowan may go to Mr. Patterson's office or call him.
All right, we're going to go back to Judge Stevens, who's dived deep into his briefcase. Looks like he's ready to open this case. Click the button. Let us in. Good morning, Judge.
I heard she's brutal. Huh? I heard she's brutal.
Okay, ready?
We're ready. Jury's here. Paper covers the camera. Well, the jury walks past the camera. This is how we maintain
And we now
privacy.
recall clause number 23 CR 727, the state of Texas versus Raymond Pickles. The defendant is present. The state's present.
Raymond
And
Peoples,
is the jury ready? Kendall.
We'll get checked.
Thank you. Mr. Laird, do you have one more witness, I think?
Yes, sir.
Okay.
Jury's ready here.
Thank you. Bring them in.
Bring the jury.
All right.
Record shall now show that the jury is present.
Hi, jury. He grins at them.
And seated in the courtroom. Ladies and gentlemen, we had to take some matters up so that we could finish all of that and then focus today on this trial. So we're not going to get interrupted again. We were able to take care of all that business. So we're going to pick up where we left off here. The state was presenting its case in chief by calling witnesses, and the state may call your next witness.
Oh, Matt Gardner.
Gardner, please come forward. Please raise your hand, sir. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Buckle up. Here we go. What do you think he's going to mention first? Poop or pen?
Go ahead.
You state your name, please.
Don't break it.
Oh, here. I mean,
don't.
This is. Don't mess with it. This is just
Don't touch it. Let go.
You messed with it. It's not that. It's not there. What you did. It was working yesterday. Let's try this.
Don't touch it.
There we go.
Okay, don't.
My name is Matt Gardner. And how are you employed? I'm a detective with the Jefferson County Sheriff's Office. And how long have you worked for them? This is my 24th year. And how long have you been a detective with them? I began criminal investigations back in 2017. Back on June 6th of 2023, were you a detective with the Jefferson County Sheriff's Office? Yes, sir. And did you get assigned a case where an inmate had attacked a guard with some pins? I did. And who was that inmate? It was Raymond Pickles. And had you had dealings with Raymond Pickles before and after that? Yes, sir. So you know Raymond Pickles. And do you see him in the courtroom today? Yes, sir. And you point to him to describe an article of clothing he's wearing. He's sitting at the table with the white dress shirt. Record reflecting to identify the defendant?
Yes, it will.
So when you got this call, how long after the incident did you get asked to come and look at this? I was on duty at the time, so it was very shortly after. The scene was still trying to be preserved for us to view it and document everything. So when you got to the scene, where was the scene at? Let's do that. So we have 2 maximum security dorms. Every dorm has a letter from A through M and N are the 2 maximum security dormitories. They each have a 6-cell isolation hallway, and then inside they have 48 cells with bars instead of solid doors. And we were in the isolation hallway for Northern. It was just the phonetic words for the letter E. That's what we call it, Northern. Was it the specific cell that you were called to go to? Cell 6 is the last one on the hallway. So did you go there? We did. And with our forensic staff. Did you look around just to kind of see what the hallway looked like, what the cell looked like? Yes, sir. Was there anything unusual inside of the cell that you found that caused you any concern, or was all of it outside the cell? Nothing I recall inside the cell. Just some items in the hallway. So looking at State's Exhibit 6, is that the hallway you looked at? Yes, sir. And when you looked, was this door already open? Yes, sir. And was this on the ground over here? Yes, sir. Looks like some bed linen. And then down the hall, what's this down here? I believe that's where we found the sock and the ink pen. Let's look at State's Exhibit 22. What is that? That look like some papers and things right there? Yes, sir. And 20, let me look at 5. This is a little closer to the blankets, isn't it? Okay. Yes, sir. I think that's the sock. Okay. Is that the sock right here? Yes, sir. And what was the purpose of that sock? It had been wrapped around one of his hands. I'm assuming to protect his knuckles if he was to fight with staff. Okay. And down where those papers were, let me show you what's marked as State's Exhibits 34, 35, and 36 and see if you recognize these. Yes, sir. Do those fairly accurately depict part of that hallway where you found the pen at? Yes, sir. Gender States 34, 35, and 36. You know,
Okay. State's exhibits 34, 35, and 36 are admitted. Thank you.
Looking at 34, going back to 32, these papers that were laying in this hallway. Does 34 show a little closer view of those? Yes, sir. And what do we see over here in this corner right here by those papers? That's the ink pen. Okay. 35 just a closer to the papers, is that correct? Yes, sir.
The pen,
And
the pen
36,
one.
what is that? That's a close-up of the ink pen.
What
Now, when
color ink
when
is
y'all
it?
went and looked, that's kind of looking at this hallway. Is this the cell door leading to number 6? Yes, sir. It's kind of a dark photo, but you can see the yellow lines going horizontally. There's 2 leading up to each cell door, and you can see a small portion of that line at the open door. You're talking about lines like this? Yes, sir. Those double lines are for the inmates to stay within when they're walking. So right here, when you're looking, is that part of that one line in front of 6? Yes, sir. Because beyond that cell, there's a storage closet, but that line helps you understand that that's actually a cell door. So there was a lot of scuffling going on between this area right here, wasn't there? Yes, sir. From what you heard from the looked at witnesses, and you also viewed the tape, didn't you? Yes, sir. So this pen that was in the defendant's hand, it ended up way down here where these papers are, didn't it? Correct. Looking again at States 34. That ended up down the hallway. With the scuffling, was there a lot of kicking and things? Stuff was there, wasn't it? It was chaos from what I viewed. And did you go and lift up any of the blankets and everything, or did y'all just go take pictures of the blankets and the pen and what all y'all found there? We took pictures of everything before anything was moved. Okay. And then we looked. And then did the trustees come and clean up a little bit? Correct. And were there also a bunch of guards that were down there with them? When you look in the video, you don't know what they're doing with what, do you? Right. So were you able to find both pens? Just the one. And is that unusual when things are a little small like that getting kicked around? Not in the jail settings, nothing. Let me show you what's been marked in State's Exhibit 38. See if you recognize what that is. That's evidence I submitted on June 6th of 2023.
You lost something shift-sized?
One plastic ink pen and one white sock. Okay. And is this the one that came from the outside, the one we just saw up here outside of cell number 6? Yes, sir. Tender States 38. No joke.
You have an 8-foot by 8-foot area to search, and you can't find a pen?
These were kind of wrapped up in gloves, weren't they? Correct.
Just stick your hand in there. It's fine. I'm not trying to preserve any sort of evidentiary value.
What's your objection?
Say anything about the gloves?
Okay, your objection's overruled, sir. That's inappropriate method of making an objection. Go forward.
Was this one of the things that was supposed to be wrapped around his hand? Yes, sir. That's what the conclusion you came to? Correct. Was there other things that they saw wrapped, but there were some things wrapped around his hand? It was either a piece of fabric or possibly a blanket itself. And is this the pen we're talking about? Yes, sir. Now, when this came out strapped to Mr. Pickles' hands with another pen strapped, were they being used as pens at that time? No, sir. They were intended use of them when used weapons. And by using a weapons, was a pen like this capable of causing bodily injury? Absolutely. Is it capable of causing serious bodily injury or death if get him in the right place? Correct. And in the manner that Mr. Pickles was using it when you're watching the video talking to the witnesses, was it capable of causing serious bodily injury or death? Yes, sir. People in the jail use all kinds of things, don't they, to stab people with? You'd be surprised, yes, sir. Is a ballpoint pen or a pen one of them? Absolutely. I worked one of those cases just a couple of weeks ago. What was that about? An officer was stabbed in the face with an ink pen, and as the inmate was fighting with him, it was still penetrating his nose during the fight, barely missed his eye. In this case, we had injuries to Lieutenant Ford, didn't we? Yes, sir. And looking at State's Exhibit 16 were these the injuries you saw on Lieutenant Ford that day?
That's some of them. There was more on his neck and chest.
We're going to get to those.
We see blood.
State's Exhibit 12, what is that?
It's the right side of his neck, some more abrasions.
And State's Exhibit 13, what are we looking at
That's
here?
the upper middle chest.
Now, when we're looking, was there some allegations that Mr. Pickles had scratched Lieutenant Ford's head with his nails?
Yes, sir.
And do you see those type of injuries on the sides over here and on his neck?
Yes, sir.
State's Exhibit 12 and 16. Leading. And also, do you see one that looks like a scratch on State's Exhibit 13?
Yes, sir.
Do you also see on State's Exhibit 16 evidence of a more sharper instrument coming down his face?
Yes, sir. There's more of a puncture wound with the drag.
And then looking at number 13, does this look more sharp than a scratch with the nails?
Yes, sir.
Does that fit the testimony or the statement that you took from Arliss Anderson, where he said he was stabbing him with the pin and raking it down from the side to his chest?
Yes,
well, for the record, you're using the pronoun he. Several he's are involved.
That's Mr.
You would help the record show who's responsible for what actions, so he isn't mixed up later. And people try to figure out what's in the record. Thank you. Go ahead.
Was Arliss Anderson's statement about Mr. Pickles, was it consistent with what we see in these photographs of a pin being used as a weapon against Mr. Ford?
Yes, sir.
And so after you looked at all this and after you talked to everyone involved, did you come up with a conclusion of what kind of charges needed to be filed?
I did.
And what charges did you file against Mr. Pickles?
The appropriate offense to charge would be aggravated assault with public servant. Yes. He was acting in sufficient capacity, discharging his duties when he was assaulted with a weapon capable of causing serious bodily injury.
And his duties, was he moving Mr. Pickles within the jail from one place to another?
Yes, sir. The maintenance department was decommissioning cells one at a time to do some very necessary security upgrades, and Lieutenant Ford had been ordered by his captain to remove the inmate, whoever it was, from that cell and rehouse him so they could get to work in the cell.
Okay. Was there anything else that day that you had dealing with Mr. Pickles? Or did you? I know you said you had dealings with him before and after, but was there anything else that day that you had dealings with him?
Nothing that day I recall.
Thank you, Selena, for the gifted membership.
I completed an arrest affidavit so we could go ahead and give him a rein on the new charge.
Okay.
And Lieutenant Ford was taken to urgent care.
Is he, to your knowledge, still in isolation?
Yes, sir.
And does he keep staying in isolation because of his behavior?
That's my understanding.
Okay. I'll pass with him.
Mr. Garland, you say you have had dealings with me before and after this, correct? Yes. Before this, what dealings did you have with me?
I don't recall before what it was.
Do you recall after?
Yes.
What was it?
What did we like to talk about last Friday?
Last Friday?
Just filed a harassment of a public servant case on me for dashing an officer multiple times with urine and feces on the phone.
You talked to me about this?
No, I didn't talk to you about it.
So when you say dealings
with work in relation to you, yes, sir.
So can you say I dashed an officer with what?
Urine and feces.
And what officer was this?
That was Corrections Officer Boyce.
And you say
just a splash, you say?
When?
I submitted the case yesterday. It's pending grand jury done. It's heard Friday.
Okay. And who told you that I dashed him with feces?
One of the supervisors let me know. They send emails to me every time a criminal incident occurs in jail.
Did you talk to him yourself?
To who?
to the officer that I supposedly dashed with?
Yes, sir.
And he told you what?
He told me that you dashed him with urine and feces. And that's what I observed on video, and that's the case I followed.
That's what I observed on video. Oh, man, he's sinking his own ship.
All right. So
is there whatnot? Sorry, was there supposed to be a whatnot in there?
Have we ever physically talked?
Not that I recall. Not maybe have. I've talked with hundreds of inmates in the time I've been in internal affairs.
But you never had a personal conversation with them?
I'm not sure if I have or not.
I'm not much of a talker.
Okay.
Worst DoorDash ever. Oh my goodness. He's got what, 3 cases against him now? He likes to let in the most damaging evidence that wouldn't be normally admissible in court, but he opens the door for it, and then he's like, no further questions, and he sits down. So he just asked about pending charges, which should not be an issue in this. But he elicited that testimony, and the witness says, yes, we have filed charges against you yesterday for failure to properly use a toilet or something similarly. And it's on video. And is he saying dashed or bashed or splashed? When one applies, I'm asking for a friend. I don't know the proper protocol. When one applies urine and feces to another, is it a dash, a splash, or a pass, or... I'm confused. A swash? A splat? It's a dash. I dabbed him. No, dab's like the thing. You couldn't see that, but it just a smattering.
Yeah, but about there.
And is it spatter or splat? No, never mind.
So, Your Honor, may I approach the witness?
For what purpose? Tell me.
Tender evidence of me and the witness prior dealings.
Well, if you're going to show something, you need to mark it for the purposes.
Make sure you recognize evidence.
Whenever you tender something, you mark it first, then you tender it. If it's not going to be used, it's just in the file as an unused marked exhibit. But if you're referring to something, you need to mark it first as an exhibit. And we've got. Do you have the exhibit stickers to mark? A defendant's. All right. Get him one. Let him mark it. That's going to be.
Let me help this.
I think that's going to be defendant's 1, isn't it?
No, 2.
Grab yourself a sticker.
Don't get.
Well, for record purposes, you have to mark it so we can know what we're talking.
I know that, but don't you have to confirm the evidence before I say it?
Sir, once again,
don't talk to him.
I was on the Rules of Evidence Committee. Right. You have to you have to mark it first, and that's how it will be seen in the record. Yeah.
Wants another sticker.
Much of this is done for posterity's sake. If something is reviewed in the future,
because we want to preserve this.
The people who are reviewing it need to figure out, be able to read it like it's a novel, what's happening and what is being referred to. Like this paper, I'm going to show you this paper, and well, what was that? It has to be referred to as an exhibit, so folks can keep up with the identification of items. Okay, you have something called Defendant's Exhibit 2. Okay, go ahead.
2 and 3.
And 2 and 3, go ahead.
If you buy novels with content like this,
first, if you recognize them,
yeah, you're going to approach him.
You need to buy different novels.
Yeah, take off. Wait. Your Honor, may I approach the witness?
Yes.
Do you recognize Miss Gardner?
Not this, not deal with indictments.
Yeah, no.
Yes. It's a report that I wrote, for implements of escape.
Yeah.
So, the defendant wants to approach the witness with his number 2 exhibit.
May I put this on?
The judge is naturally hesitant.
No, sir, it hadn't been admitted yet.
No, it's in there.
That's why I've asked you, please, if you need somebody to stand by, sir, you've got to act under the rules of law as lawyers are required to do. And when you represent yourself, you have to put yourself in as though you were a lawyer. That's why anytime you want to change your mind and get a standby counsel, let me know.
I don't think
because
you
want to do it. We got to
how
correct. We have the rules, sir.
That's how y'all explain the routine.
Judge, since he identified 3, I don't have any objections to it. 2.
Can stipulate to that too? Because that was
Yeah,
not
identified. I'll object it, so I don't mind 3 coming.
I'm sorry, what did you say?
I object to 2 because it did not identify it. It's an indictment. It's not properly formed, but the other one I'll let in.
Okay, hold on. So you have no objection for defendants 3, but you are objecting to defendants 2?
Yes, sir.
All right, let me see that. Let me see.
2. He needs 2.
Yeah.
Oh, you need, no, you say you need 2. No, sorry.
This is 2.
This is 2.
Judge, don't sniff the paper. You'll regret it. Thank you very much for the island, Iowa man. Appreciate it.
Okay. You write a 2 like a 9.
You wrote.
That was me.
Is that what you did?
You know my handwriting.
Defendants 3 is admitted. You can refer to that.
Am I allowed to put it on the bulletin?
3? Yeah.
3, yes.
Yeah, it's admitted.
Mr. Laird, did you?
Yeah, you can just
display it.
Oh, okay.
I can turn it on.
Iowa woman. Did I call you Iowa woman or Iowa man? I'm so sorry. These glasses do not actually help my vision. They just block the blue light. I probably need a combination that does both.
So, I'm gonna go ahead and read out this whole thing. The paragraph or whatnot.
Look at the judge's face.
You say you remember this report, but you don't remember talking to me ever, right?
Sir, I said I talked to hundreds of inmates. I didn't recall if I'd had a personal conversation with you.
Okay.
I filed so many criminal cases for things that happened in the jail. I can't recall the facts of every single one independently.
So do you normally talk to the inmate before you file those charges?
It depends.
It depends. What do it normally depends on?
This trial is now sponsored by Depends.
Just an open-ended
good choice
kind of question. I don't know how to answer that for you.
I mean,
it could depend on any number of the factors.
Okay, let me ask you this factor. So, if there's not enough substantial evidence to charge an inmate with a crime, would you consider talking to him then, or do it matter?
If there's no evidence, I don't file a case.
Don't file a case. So, if there is evidence and you file the case, it still varies whether or not you would talk to him?
Yes.
Okay. So, on the escape charge, right? What would vary in this type of situation for you to talk to an inmate?
What do you mean by that?
Like for you to meet with the inmate and talk and discuss if the inmate, whether or not the inmate was trying to escape, right? His intent for you, what would have to, what type of aspects will have to vary for you to say, okay, well, this is enough for me to go and meet with this inmate to talk to him?
Well, your intentions were pretty clear on the video, but I wanted to ask you if you could explain what your intentions were.
Oh, okay. So you wanted to ask me to explain, even though it was clear, you wanted to ask me.
Yes, sir.
Why is that?
To hear your answer.
To hear my answer. So if it's necessary, if you feel like that was necessary to hear my answer, even though the evidence was clear, right? Why didn't you come talk to me before you filed this case yesterday?
Even though the evidence was
to
clear.
Hear my answer.
I didn't have any questions on that one.
I mean, it was clear that I did it, right?
Yes, sir.
So why didn't you have questions?
Because I didn't need to know what your intentions were when you propelled a liquid combination of urine and feces onto one of our staff.
How do you know it was urine and feces?
Because of the odor and appearance that the staff explained.
The odor and appearance?
Yes, sir.
That's
it's a pretty distinct odor. I think every reasonable person's aware of that.
The odor and the appearance.
Is that a question?
So the odor, I'm assuming you talked to him immediately after I dashed him, correct?
No.
When did you talk to him?
I talked to him Friday, but not immediately after.
The same day, though, correct?
I don't recall.
You just did this on Friday?
Thursday or Friday, but it was last week that this happened. But I worked the case Friday. It was probably Thursday morning if it happened. But again, I don't have that in front of me to reference. I work so many cases.
No, that's so. Is it normal that you would wait days later to talk to a CO after?
Not days later. Like I said, sir, I receive emails daily from the jail supervisor. Anytime there's a criminal incident, I get an email. I get reports attached.
All right.
And I said I worked this case Friday. I believe that the actual incident occurred Thursday. So when I come in Friday, I have that email from the conclusion of that shift saying when it occurred.
Okay. And did you collect the evidence of his clothing?
No, so we photograph it. We don't put that in the bag.
Why not?
Because we have photographs of soaked clothing. We have video of it occurring, coming out of a cell with one sole occupant that was used.
So,
and because the statute itself does not require that it's actual urine and feces, it can be any fluid thrown onto any person in a jail. But it's just a little bit of an aggravating factor for you when it's urine and feces and not just water.
So you say it can be any liquid?
Yes, sir. If you dash an officer with a cup of water, it's a third-degree felony.
Okay. So in this instant, right? Correct. In this instant, it wasn't water, right?
That's what they said.
Which means it would be DNA, correct?
I'm sorry. Ask that question again.
Which means there will be DNA on his clothing, correct?
I would assume there would be.
So wouldn't it be more of a what's that word I'm looking for? Procedural to collect his clothing for DNA?
The proof of what the substance is not necessary to establish the elements of the offense.
So give a person life in prison just because you feel like it? Is that what it is?
It's a third-degree felony, sir. That's 2 to 10 years.
So I'm asking, is it normal for you to not collect the evidence before you charge a person with a crime?
It depends on the offense.
On an offense this serious, is it necessary?
It's not necessary. We have photographic evidence and we have video evidence showing the offense occurring.
Do you agree that offense is very serious?
It's serious.
Very, right?
It's a pretty serious violation of somebody's personal space when you put your bodily fluids in it.
Right. So with that being so substantially serious, why isn't it a part of procedures that you collect the evidence before you charge?
Because I have photographic and security video evidence showing the offense occurring, and it is not necessary to have the substance tested to confirm what it is to meet the elements of the offense to charge him.
Okay. So, but we do agree that we have personally met before.
It would appear so, yes, sir.
Would appear. You remember once you seen that paragraph that we met?
Once I saw the report that said implements of escape, I remember the time you attempted to escape from your jail, yes, sir.
All right, and remember us talking?
I don't recall the conversation. It's been a while.
You don't? Would you, Mr. Laird, would you happen to have the evidence on that since the detective is testifying?
Do you happen to have some evidence for me?
The implements for escape?
Are you talking to me? You're the one who's supposed to be prepared for trial. I can put a whole lot of stuff in here.
Well, you wouldn't.
I don't want to do that. I'm trying to avoid doing what you're.
You wouldn't allow me to prepare, adequately prepare, because you were supposed to tell me.
I'm sorry. You know, this discussion is going to be in.
Okay, sorry.
This is discussion, you can hold it at a different time, not in front of the jury. My goodness, that's not appropriate. If y'all need to discuss legal issues, do it outside the presence of the jury. Ask the questions. The jury is just here to determine what the evidence is, not what's going behind the scenes, okay? Ask your next question of the witness. That's the proper procedure. Thank you. Go ahead.
All right. So after me and you met and talked about this, do you remember why you charged me? Let me reiterate that question, sorry. Do you remember me telling you I had no intent to escape?
I put that in my report, yes, sir. That's what you said.
So is there a reason you would charge me after I said that?
Because as I said, your actions on the video were clear. I just wanted to hear if you would tell me why you were doing what you did.
Okay. So is there a reason you didn't draw up a probable cause affidavit for it?
I believe you've been indicted on that, so I would have. Again, this is not the case I'm here for today, so I don't have those documents to reference.
No, I mean, it's in reference of the case because y'all talking about, we are talking about my behavior, correct?
Yes.
And this is a part of my behavior, correct?
Absolutely.
So it's very clearly referenced to this case, right? In jail.
Sir, I don't bring every case file for you to a trial for an aggravated assault. I just have the information on the aggravated assault.
I mean, if you wanted to prove my behavior being so atrocious and monstrous, wouldn't you want to bring that evidence to trial?
So I'm not here to prove your behavior. I'm here to answer questions.
Right. And I'm here to answer, correct? I mean, I'm here to ask, correct?
Yes, sir. Ask for it.
That's why I'm asking about this. Right. So that's why I'm asking. Why didn't you drop a probable cause affidavit for this?
Sir, I said I did.
Oh, you did?
That's how you get indicted. I have to request that the warrant be issued for your arrest and follow the calls out there.
Have it. Hey, have it. You know what's probable cause affidavit?
Yes.
There you go.
Because when y'all gave me this, I never got it.
No, sir. Hold on.
It's a different
We're here
case.
on an indictment for aggravated assault against a public servant. You're bringing up now other types of misconduct. That's your opening of the door. That's your opening. That's not what this jury is supposed to be. And you just interrupted for the whole time. Sorry, court.
Sorry, Your Honor.
Please follow the rules. Once again, this lady has to take everything down, and when you interrupt and speak over the court, she can't take two people speaking. And that's what the rule of law is. When the court speaks, you have to stop. You have a fair opportunity. But we learned this when we were children.
Yeah, we did.
Okay, well, follow those rules, Mr. Pickles. You're able to do that. I know that.
We also learned.
You brought this
wash our hands after
extraneous type behavior out. That's what you're doing. The four corners of this indictment are what happened on or about June 6th, 2023. In result to this first degree felony indicted of aggravated assault against a public servant. So if you want to go into extraneous acts, number one, they have to be relevant to this case. And number two, that was something that if that was your plan, you should have inquired with the state on any discovery. And in the middle of the trial, it's hard for them to stop what they're doing on one case and then go look for something when it wasn't indicted. So you think about that. I don't know if they have information, and I don't know what you're heading for in bringing this up. But again, we're talking about the jury's chore and job is to determine whether or not it has been proven in this case that you were guilty beyond a reasonable doubt of aggravated assault against a public servant on or about June 6, 2023. Other extraneous type behavior can be relevant only under limited circumstances, because the general rule is you don't throw every bad thing into a jury, in front of a jury. It's what's relevant to the allegation of this indictment. Some people have numerous indictments. Each trial deals with those specific facts. But right now, we're just focused on this one, this indictment. That's for the jury to determine. So let's try to focus on the relevant facts for the allegations in the indictment. That's what they're here for.
Your Honor. Absolutely. But I would like to note to the court that the court and the state tendered this evidence for me to question the witness. So, I mean,
I didn't tender it to you, but the state did. And if what is it that we're trying to focus on if it's not one of the elements of the crime in this charge? Why are we straying? Because this could last, theoretically, this could last 100 years. And it's not funny. That's why relevance is the whole essence. You deal with one charge at a time, and you deal with every fact situation in a charge, and a situation has its own circumstances. And that's why sometimes we try many cases with the defendant. But we're trying to focus on this one trial, this allegation. Other allegations that don't have relevance to the elements of this crime are irrelevant, and for another time, another jury, another indictment.
Right.
Okay.
The state asked him if he had dealings with me before and after, and he also asked specifics about my dealings also. So I figured if he asked about other dealings, I mean, I could ask also. I mean, seeing that the state is holding me to the same standards as a...
Here's your probable cause. If you want anything else, then I'll give you anything on that charge you want. You can sell it. I'll put it in myself if you want me to.
So
how do you sink your own ship in 3 easy steps?
I gotta ask, why wasn't this a part of the stuff you gave me for trial?
I had no intentions of trying to.
Once again, y'all's discussions outside the presence of the jury, just y'all can talk about this at another time.
Take a break for him to look over this file. I'll be glad to let him look over the file. If you want to give him 5 minutes, I'll be glad to let him look.
Don't bring the jury into discussions that are not relevant.
Well, I mean,
they're determined.
Y'all brought me out here 2.5 weeks ago.
Sir, just ask questions. You ask whatever questions you need to. You have a witness, ask the questions. Don't be discussing this in front of the jury. We can do this outside the presence of the jury. It's inappropriate for the jury to hear things that aren't evidence for the crime at issue. Please stay focused on that.
I need a 5-minute recess to ask him about the other relevant evidence to both of these cases, because I feel like
we can do that later. Ask what other questions do you want of this witness while you have him here?
Well, for me to adequately construct my questions to the witness, I need to make sure my knowledge of both cases is up to par, because it looks as though I'm missing information to both cases.
You claiming a discovery violation?
Here's what we're going to do, ladies and gentlemen. We're going to take a short break.
We're taking a short break,
Please
guys.
bear with us. And
Please bear
relax, stretch your legs.
Bear with
we'll
us while we take a short break.
As soon as possible. Thank you.
Everyone bear down while we take a sharp break, and we'll be right back. Right back, excuse me. Excuse me. He said it, not me. We're taking a it'll just be a couple, maybe one, maybe 2 minutes is all, I think. This trial just keeps giving. I have given up. I was supposed to count whatnots. I've got 9. I've got 9 whatnots.
You're supposed to be reading? No, I don't have to. We're supposed to be talking about me giving.
I'm fixing to get a copy of this for you.
Oh, Mr. Larry, can you please? Okay, he said he charged me Friday, which means but I haven't been arraigned. Can you please?
I don't have that because it hadn't been in front of the grand jury, so it's not something that I can give out to you.
When he had filed,
you brought it up. I didn't, and the reason you do that is you don't bring that stuff up because it's not been indicted yet. I haven't touched it. You have.
Yeah.
I'm tired of arguing with you. I'm going to give you this.
I'm trying to argue with you. I didn't bring it up. I didn't know he charged me with it.
No, you want him in the back?
You want him in
the back? No, the other inmate wants some water. I'm gonna keep him. That's
Let's go ahead and talk to you. Not really, sorry. Mr. Pickles, do you still have the PC affidavit? Yeah, let me have that. I'll get you. No, it's not that one. You don't have that. The one that mine said, okay, you did whatever it is.
It should be 4. Is that 4 on there?
Yeah.
That's it.
I'll bring it back to you.
This is a mess. This is a cluster. The witness is talking to court staff about the case. The judge has left. The prosecutor's left. The defendant's still here, talking to the witness, who is under oath, literally seated on the stand. Judge is taking a sharp break. And we have a hotline.
No, we talking about everything. Y'all have to push this box. Because I'm bringing up everything. You might secure it today. I'm talking not about to keep me in prison. Shoot myself. I don't want to. You know, make sure. I had us all that from my boss here. We say, Mr. Gardner, have you filed that?
We're not.
Sorry. Sorry about that.
You can look over your stuff. Casey's going to question you about it.
Mr. Larry, have you filed it with the DA's office?
What?
The charge you told me to charge me with that.
He's given it to my office. I have not got a copy of it because I don't do grand jury. He goes to the grand jury. Before the grand jury looks at it, it's not officially a warrant or anything for you. It's just there. It's going to be taken care of next week, but I don't know why you won't get into all this. It's hurting you, not me.
I didn't know he did this. He was. He bronchitis. I do. That was new information to me.
I'm done.
Doesn't help. I don't play with my feet. I don't play with my girl. Sure do. No, I do not. I got plenty of witnesses in that jailhouse that would tell you. If y'all would let me call, I plenty of witnesses that would tell you. I never played with my feces.
I have never played with my feces and urine.
Get some DNA on that. Yeah, I dashed them with water because they took my vehicle.
You get that on the record.
I know that's still a shame.
It's the same office.
He just confessed.
Yeah, we're not doing this. Matt, just not here. We're going to stop, Matt. We're just going to let him do things.
Let's go to the back. We're going to go to jury room. So who was this? This was after.
Huh?
Yeah. I'm talking to myself.
This is copies, right?
All business.
It's copies, right?
Well, they do
Alright, you just made him copies, right?
Yeah.
That's the other side. Okay, so y'all got your.
I got my copy, that's his copy.
Okay.
This is nuts.
He's free to bring up all the stuff in my state.
The witness.
He's coming that way soon.
You want some water? Yes, please.
Come this way.
Witness is messing with the evidence now. Everyone's out of their office. Out of the room.
Hold on.
Yeah.
Everybody in the sheet fronts, no arguments.
So you guys want to know? You guys want to know what happens on a break?
Yes, he's bringing up that he tried to escape from, he tried to escape from jail, and he's letting me talk about him action in office. But he said, well, Mike said, have you had dealings with him before and after this? I said, yes, he did not explain all that. He doesn't know the problem. He can't pay Nora's box and again, this thing. You're not received as July of 2024.
You sure? Yeah.
So the witness should be not be talking to anybody about their testimony.
I had to remind myself when I got in the hallway. I knew this was going to be a circus. It's like I'm better now. I'm good.
We'll just keep that. Don't worry about what the end result is. Oh, no. Don't argue. Mike, no side conversations with him. Mike,
yes, I'm trying to.
Mike, when he turns and he asks you something, don't. Just don't.
Okay.
No. Even with that, he's very cordial and helpful to the guy. Yeah. Most people would just say, not your problem. You're tremendous. But you want to stay that way. Remember how I was so
I know. But also, last time I had one relationship, he was that way, and I was nice, and they didn't like it that way. But this is
different. I'm telling you, watch his body language. He knows he's losing. He's falling back. He's falling back
to his old pattern. I know.
I
know that. If you were sitting here, would you be as calm?
No, but the roles are reversed. Today's my time to do what I'm doing.
I know. I'm good now.
You'll be doing this for me when Shannon Upton.
I'm just gonna let him put on. If he wants to put that on,
you don't work alone.
Because this dude wasn't talking to that girl. He passed that girl's cell and went off. He had a trustee's uniform on. He had a great thick blanket stuffed inside so he could get over the barbed wire.
He made a guy in his bed. He said he saw it in a movie. No, he's an absolute idiot. Oh yeah.
You were going to bring that?
No,
no, I just hate to see somebody shoot themselves in the foot.
Hi there. Oops. Oopsies. Oopsies, is this mic still hot? Sorry. I'm sure everyone in the room just stopped talking. Just like they're done. There's nothing going on of interest in the room right now. It's over. Everyone's just sitting with their arms folded, sitting on their hands, just waiting for the judge to come back in. She's a party pooper. Prosecutor talking to the witness, instructing him not to get involved in these side conversations. The witness is on the stand. He's literally coaching the witness in how to respond or not to respond to different things that are presented on the stand. Completely inappropriate. The defendant, completely inappropriate, has the laws the judge mentioned about relevance. Okay, when they say probative versus prejudicial, those rules are put in place to prevent prosecutors from bringing up all the other, pardon my pun, crap in your history or in your file or in your calendar that could show that this is, you have a propensity to do a XYZ, or you've been known to be a bad guy in the past. You've been known to show violence towards corrections officers, or you have problems getting everything in the toilet, and sometimes it gets on other people who walk by your cell. Whatever the case may be, those rules are to protect the defendant. They're literally restrictions on the prosecution, what they cannot do, what is not permissible. Because if the jury, heaven forbid, should hear word, catch whiff of that, they might hold that against you in this case. This defendant, instead, is fighting tooth and nail. Give me a copy of that indictment you filed on Friday for doing the same thing. What, you have video there? Tell me all about that. Oh, the state needs to object. He's losing. I mean, they're literally getting everything they could possibly want. No jury in their right mind is going to say this passes the smell test. This defendant stinks to high heaven when it comes to these charges. State's not concerned. He's laughing. The state thinks it's hilarious. I'm going to let him bring it in. He says, I'm just going to let him. Just going to let him keep going. Defendant is helping the prosecutor prosecute him. He's convicting himself not only in this case, but in the other ones as well. Literally, with the record rolling, well, not the court record, but with the camera rolling, so on video, recorded for posterity to see, we have the defendant admitting to throwing a liquid on a corrections officer, which is what they say, a class 3 felony or something. He admitted to all the elements of the crime. Be it urine or water, it is the same. He says it was water. Doesn't matter. Punishment is the same as if it were urine or anything else, or Kool-Aid or alcohol. So the witness is like, can we get that on the record? Yeah, he heard it himself. He observed it. If this goes to trial on that charge, if we get through the same process and we find ourselves in this little circus again, that witness, that investigator can get up and say, I was here, I was sitting in this courtroom when I heard the defendant say, I threw water on that officer. Here's the timestamp. There's a YouTube video with it on it. Here's the channel. Fred Smith, welcome. There's a short delay between when you subscribe to the channel when you can talk. We apologize for that. It's not for you. It's for the trolls. It keeps the trolls out and keeps the conversation clean. Today, not so much, but as soon as you can talk, please make yourself known. But we appreciate you clicking the subscribe button. This is why you don't represent yourself. Oh, my goodness. This trial is more evidence than the world really needed. Really ended a while back, and this is all a simulation. This is a cluster. Yeah, we're not this goofy normally. We're taking a break. The rest of the true crime world, you probably are well aware, is following an extremely heavy case. We are intentionally providing a lighter environment. We're not following that one. It is a heartbreaker. I don't know how you can watch that and just not just be gutted to your very center with the tragedy and the the awfulness of the situation. But the judge is back. He's going to hopefully unmute us. Please, Judge, unmute us. And bring the jury back and pick up where we left off. Thank you, Your Honor. Appreciate the unmuting. That button right there.
All right.
That's it.
All parties are present. We're ready to proceed. Please bring the jury in. Thank you. Tom, do you need me on something? Tom?
No, Your Honor. I was just here hiding. Thank you for noticing, though. Hopefully not.
You may not be aware of this, but you stick out.
Yeah.
You're the tallest person in the room. If you're going to hide, go to the basement. You got to go to the basement.
Bring back Giles. I'll hide where I have to go.
I was just here hiding. I was just ducking the flying poo.
Using my courtroom as a hiding spot.
This has been a hilarious comedy of errors on the defense part. Are you whispering to someone, Judge? Yep. And it's the YouTube channel. I think they're going to take us down. So while we are watching and learning about pro se defense, what to do and more appropriately what not to do.
I'll have to look and see if that's a possibility. I don't know how to do it in my opinion, but yeah, I'll research it, Judge.
And the record shall show the jury is present. All parties are present. Thank you for your patience, ladies and gentlemen.
Fran Fitzgerald, welcome.
Let's see what happens next. And the defense, I think, Mr. Peoples, you're up, and you're asking some questions. Next. Go ahead. Take over.
OG, Fran, thank you so much. Let's see what happens next, says the judge. We're all waiting with bated breath, or holding our breath, as the case may be, at our noses. They cover the camera so the jury's not observed when they come into the courtroom. And we have court watchers today, a couple more. I wonder if we know them. Ponder, think.
How many times have I wrote agreements to you? Don't pay attention to them.
I answer thousands of those. We have almost 900 inmates, maybe more sometimes, and I answer those every day. So I have no idea. I doesn't focus on any one particular inmate, just the inmates.
How often do you read a report about me?
I also have no idea. I read reports about hundreds of inmates every month.
Don't nobody ever mention me to you or bring me up about anything, situation?
Like who?
Other than, the stuff you tried to do. Nobody ever brought up to you about me causing problems in the facility?
I'm not part of shift meetings to hear any of that stuff. I have an office. I'm not part of the jail staff.
So this is the first time you heard about me throwing feces on the office?
No.
You have heard it before?
Yes, in the case we're here for today, the last paragraph of my report.
All right. Other than this one, is there many Any other?
Other than those two?
Yeah.
Not that I can recall, but I would have to look through my spreadsheet to see how many times your name is on them.
Lieutenant Ford, when you claim I dashed him with feces, were you working at Jefferson County Correctional Facility?
No.
So how did you know about that?
Because he told me.
So is it fair to say that other people do tell you about other times that I of my behavior throughout the facility?
If it's relevant to my investigation, I ask the question.
Have anybody ever told you I punched any other officer?
I would have to refer to my spreadsheet to see if your name is on there for the assault case. I don't recall. I don't have an eidetic memory, sir. That's why I have notes in the spreadsheets.
Well, I asked you that because I wanted to ask you this. If you never heard of me throwing waste on any other officer but Lieutenant Ford, right? Right. But you wasn't, I think you wasn't here. Okay, let me reiterate that question. Why didn't you charge me with throwing the feces on Lieutenant Ford once you found out about it?
Because I was not the detective assigned to internal affairs at the time, and there was no resources preserved for me to present the case. I didn't have video and photographs. Otherwise, I would have.
And it's on record, right?
What do you mean?
Like, you put it on record that I bashed him with, I threw feces on him, correct?
You made a report, yes.
In that report, did he request criminal charges be brought against him?
That's my understanding, yes.
So why didn't he?
Why didn't I?
Yeah.
As I said, sir, I was not the detective in internal affairs at the time. I was downtown with the criminal investigative division.
Yeah. Do that really matter?
Yes.
You don't have to have knowledge of a crime and proceed, even though he wasn't.
Sir, I was working in special crimes, helping young children and female victims at that time. I was not working in any cases with the jail. That detective is since retired. I cannot speak for him about why he didn't work the case back in 2022.
Has that ever happened when a crime that happened that you wasn't around and that used to be under somebody else's name, you never came back and pursued charges?
We've all worked cold cases, but those are homicides that we do. We don't bring up incidents in jail to past and relook at it.
So you are allowed to prosecute cases that wasn't under your name before?
I can, but that was not my job to do that. I didn't have any evidence preserved to present a case.
Testimony will be evidence, correct?
Sir, would you be comfortable being charged with an offense with no evidence to show? No video, no photographs?
I wouldn't be.
Okay, that's why I didn't present a case on you for that.
Back and forth.
So
to be fair,
if that's why, right? Do you think I would be comfortable with being charged with a crime that you also have no evidence on as far as DNA?
I don't need DNA for a harassment case, sir. It can be any substance whatsoever. That's what the penal code says.
No, it says bodily fluid.
I'm sorry. No, sir. You're not. No, sir. This isn't a debate with the law. I will give them the law. Ask him a question. Ask him a question. Don't debate over what the law is. Thank you. That's my job. Ask your next question. If you're going to represent yourself, you have to do it properly under the rules. Stay within the rules. I've said this numerous times. It's not a debate. You ask him the next question.
Ask the witness.
What did you say, sir?
Ask the witness. I'm done.
Anything else?
No.
Is this man excused?
Thank you, sir.
You are excused, sir.
Thank you, sir.
Next.
Just take a rest, John.
You're up. What do you want to do?
Yeah. Well, I mean, of course, you're not going. If I ask you to being a witness. Of course, you're not gonna do that, correct?
You were supposed to do that
I want to
when you represented yourself. That's what they do. And I asked you, get some help, and you refused it. They're the ones who know how to do it. You don't do it in the middle of the trial, sir. These people have things to do. You're supposed to be prepared. You said you were ready. You insisted on moving forward. But we can talk about this at the lunch hour. Is there anything you want to bring up other than,
testify.
You do?
Yeah.
All right.
He's going to testify. There
You may call yourself and come forward. Yes, sir.
Now, anything you bring up and have notes, the prosecutor can look at.
Have a seat, please.
Here's where it goes off the chart.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this trial will be the truth, the whole truth, and nothing but the truth? So help you God.
God.
Lower your hand, please. Please sit. Be seated. Ladies and gentlemen, when a person wants to represent themselves and make testimony, we don't have anything built into the system where we play like a question is being answered.
So he just gets to talk.
This is question and answer. This method, when a defendant wants to represent themselves, it's different altogether. And this is the exception to the rule. He may make a presentation, an oral narrative, and then when that is completed,
or a fecal narrative,
then the state gets to cross-examine. But it's not a question and answer. In this particular case, when a defendant insists on representing themselves and testifying, they get to make a narrative statement, and they're going to be held to the rules that it needs to be relevant. It's to the allegations at issue in the four corners of the indictment. All right. You're on the stand. You've been sworn in, Mr. Peebles, and you may go forward. Thank you.
Talking to the mic, please. We need this. Is he going to ask himself questions?
I'm 35. I'm a 37-year-old man. Born in 1988. I moved to Texas when I was 18 years old. I was born and raised in Detroit, Michigan. I have four children.
Four, sorry.
3 boys and a girl. First time I've ever been charged with a crime was when I was 27 years old. I work out. I'm healthy. My health is in great shape. So if I start shaking, foamish at the mouth, looking as though I'm having a seizure, which I've never had in my life, it's because you're talking about something that you don't want me to talk about. And they are electrocuting me through this shock box that they got on my leg.
They're electrocuting me with the shock
box? They're electrocuting me through the shock box that they got on my leg because they don't want me to talk about the prior cases and why I'm in here and all the stuff that they've been doing to me since I've been incarcerated.
They are electrocuting me.
Yeah, I'm very scared right now. You know, all my kids are watching this because I told their mothers. Make sure they don't go to YouTube and watch these.
Because it's about to go down.
One of them 15, one of them 14, one of them 11, one of them 4. I'm disappointed in time and time again They thought I was coming home so many times. I thought I was coming home. But because I'm outnumbered by the government, and there's so many powerful people in the government that hate my guts, not because of what I did to them, but because of who I am. When I got arrested, I was working in night hall. It was contracted with several different plants. We did environmental study. I was working with them for about 2 years, very consistent. I also started working back in my old job at an arcade for kids. So I was working 2 jobs, and I was still able to make a lot of time for my children and my wife.
Bless you.
I don't understand why these people want to keep me incarcerated so bad. I have filed numerous affidavits throughout the years telling them that I wouldn't file a lawsuit. They just let me go home. But I'm not about to sign for nothing, because if I do, I won't be able to get my job. That signing for anything is not enough. I've never been convicted of an extraneous crime before, and I'm not about to start now. I was a law-abiding citizen. I've lived 7 years of my life fighting for people in cases that they know I didn't do. So yes, I'm about to talk about every single factor from the day I was charged with the first illegal crime back in 2016, all the way up into this new crime that he just told me about, of some feces being thrown on somebody. And everything that I'm about to mention is on record.
And whatnot.
Or I have witnesses about it. And I'm about to educate the jury about the law that y'all keep breaking, about the rules that y'all keep breaking, and how y'all like to keep trying to manipulate stuff to keep me in here.
That was the warm up. That was the.
They talk as if they don't got a personal problem with me. This is my 4th trial. My 4th trial. And the only time they were able to get a conviction was when it wasn't a jury in front of me. And that conviction came from a probation violation of a charge that they had no jurisdiction over in the first place. It was supposed to be in misdemeanor court, not felony court. $7 years. Yes, I'm about to exploit all this evidence.
Exploit it all.
So I want to start by talking about
2016 is where we're starting.
This partial jury trial that's going on right now. It's completely unfair jury trials that they forced me to go through right now. Doing a jury selection 2 days ago. And then 30 minutes into it, the judge don't sit up here and say, well, you need to make sure you ask the questions right and do all of this, because when the lady starts transcribing this, she's gonna need to. And it was 30 minutes into it. I said, y'all not transcribing this? We're about to.
Hold on, sir. Sir.
What?
Sir, let's get relevant here. You were charged with the 1st-degree felony of aggravated assault against a public servant. This isn't the time to make a speech of your whole life. Let's stay within the relevant allegation. And don't interrupt the court. I've said, how many times have I said that?
7.
You have a fair opportunity to be heard. The court is required by law to direct the law to the people, and the jurors are instructed. We are focusing the relevant matters of the accusation in the four corners of this indictment. Let's stay within this. This isn't time for your life story. If you are found guilty, if we go to the punishment phase, there are matters you can bring up that are relevant to punishment. This is only about the allegation. Please stay within the four corners of the charge. Thank you, sir.
The jury, the day I'm talking about is the jury selection for this charge. So
stay within the four corners of the charge in this indictment. That's what's relevant. Thank you for following the rules.
That's what I'm doing. So there was no point in me objecting to what I was seeing on the jury selection paper because he wasn't.
Once again, sir, this is with the four corners of what happened on or about June 6, 2023. Let's don't talk about jury selection. This was all, that's not relevant to the facts. Stay within the facts, sir. Please go forward.
The Sixth Amendment says the accused shall enjoy a speedy public trial by an impartial jury. The word impartial means fair. In the district, whereas the crime shall have been committed, which shall have been previously ascertained by law, shall be confronted by the witnesses against him, which means the witness that's against me shall have said that I did whatever they charged me with. And yesterday, that man sat right here and said, yeah, you scratched me. That's how I got my injury. He sat right here after we read out, the victim sat right here after we read out his report. And he said that his report was accurate. And he said, yeah, after he got done lying and perjuring, he couldn't help himself. He had to, you scratched him. That's how I got my injury. But yet I am indicted for stabbing him with ink pen. And you're talking about standing before corners. That's exactly what I'm doing. The four corners, matter of fact, all persons born or neutralized in the United States.
Naturalized, sir.
Naturalized, thanks for correcting. You're right. Naturalized in the United States. Ooh, you know this. And you know it.
Sir, okay, please move forward with what you need to say.
Born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. No state shall make or enforce any law which shall abridge the privileges and immunity of the citizens of the United States. Last I checked, I was born in the United States. Nor shall any state deprive any person of life, liberty, or property without due process. Last I checked, me talking about how unfair a jury is, I had the right to do that because my right is being abridged. So I can tell the world and explain how my rights are being abridged during my testimony in the four corners of the indictment. Is that correct, Judge?
Sir, move forward and stay relevant to what the allegations are in the four corners. And please, for the 20th time, please don't speak over the court when I'm speaking. Sir, how many times have I said that to you? You have a fair opportunity to speak, but it's not on your terms. The law has its rulings. The rules of evidence have its rules, and you, in representing yourself, must follow them, whether you like it or not. You have to stay within the rules.
Careful, Judge.
It's just not a full-blown part where you have just anything to say without any restrictions. That's the way the rules were built. And
we might
you have to follow the rules and stay within the four corners. And this is what the facts are that is alleged of wrongdoing in this indictment. Please speak to that. This is your opportunity. Go forward. Stay relevant.
Yes, Your Honor.
Move forward, sir.
I would like you to let me know if what I just said was correct or not.
It wasn't relevant to whether the facts are, I give the law. You don't start quoting constitutional law. I'm going to give the law, sir. You just talk about the facts. Please move forward. These people have valuable time here. Let's stay within the rules. Give them what your version of the facts of this incident were. Please move forward. That's what we're here for.
So you above the laws of this country?
The bailiff is
I
about.
was just asking
You one more statement like that, and I must hold you in contempt of court. I don't want to do that. I've ordered you to follow the rules. Please follow the rules. Direct the attention of the jurors to the facts as you want to say them in this allegation. Thank you.
Nor shall any person be denied within the jurisdiction.
I give the law, not you, sir. Just talk about the facts of this case.
Equal protection of the law.
You're not going to follow the directions of the court and the rules? Or
I see how Jesus should.
That's your statement?
I'm testifying, Your Honor.
To the facts of the case, sir.
So you telling me I can't be a character witness to myself?
Sir, give what you want to say to the jury of the facts within the allegations. That's what we're here for.
I'd get that
The
stun
jury
button.
is sanctioned by law.
I'm sorry, sir. This isn't a debate. Go into the facts of the case, please. I've made a ruling. Follow the ruling.
I'm being a character witness. Can I call myself as a character witness?
You don't do it that way. You can speak.
Can I talk about myself?
Yes,
as a character witness?
The character as to character is not relevant at the guilt or innocence phase. It's at the punishment phase. You can talk about what the facts are and what might have been motivations. I'm helping you out on this. You might have been what motivations that you had in acting within the allegations here. I can't tell you what to say, but character evidence is something that is reserved for the punishment phase, where the jury is to decide what the punishment should be. Right here, it's to determine, did you or did you not commit the offense? Not, are you a good person or not? It's about the facts of whether the allegations have been proven true beyond a reasonable doubt. That's the rule. Please stay within that rule. Go forward.
So the DA can destroy my case.
Go forward, sir. They can ask you questions on cross-examination, and you have an opportunity to do redirect statements on your own later. That's the law. You should know that.
For the last 2 days, you've been destroying my character.
Well, sir, that's
I can't rebuild it.
you should have objected.
I did object. You told me that didn't make it. I did.
Okay, move forward. Move forward, sir. Speak on the facts of the case, sir.
I would like to object to the jury selection.
Overruled. Go to the facts of the case, sir.
But I need to.
Sir, it's overruled.
Before you.
Sir, it's overruled. Okay. You move forward and we'll take. I'm sorry, sir. We'll take that up outside the presence of the jury, and you'll have a fair opportunity to make your statement and put the rule on, but not in front of the jury. That's not what's relevant for them. They need to know what the facts are, not what your personal feelings are about this court. Move forward.
That's not the way.
Move forward, sir.
We're about to see a taser.
My objection before.
No, I will do it outside the jury. We'll do it outside the presence of the jury. That's not relevant. Go.
They can do it at the jury selection.
No, sir. No, sir. That's not the appropriate way to do it. We're going to follow.
Appropriate way, Your Honor.
I've made my ruling. Move forward. Talk about the facts of the case, sir.
I love y'all. Remember, I love y'all. I'll never forget. This is what resilience is. This is what perseverance is. This is what integrity is. All my family that is watching this right now, this is what integrity is. This is what dignity is. This is what perseverance. You understand me? Don't ever forget this. Don't ever forget this. So, every juror in here is related to an officer in this county. I have a few lawsuits that's naming a lot of officers that did some real foul, atrocious stuff to me throughout these 7 years. The fact that I have a lawsuit pending against this judge right now, and the federal district judge, and they still forcing me to sit in front of a jury that's not my peers, it's completely illegal. It's completely overstepping the Constitution. 3 of the jurors had close relations to Mike Laird by their own admission. One of the jurors was related to the guy that arrested me, to the officer that arrested me and broke my phone and destroyed my evidence. That I had, the same officer that I had to prove set me up and framed me at the last trial of a jury that voted in my favor 11-1. Nobody in this country would have voted in my favor. That juror that voted against me was planned, was temporary. I'm still in prison for pointing a gun at somebody. Pointing a gun, which is a misdemeanor. I didn't shoot the gun. I just pointed.
Oh my goodness.
By law, that is a misdemeanor. They charged me with aggravated assault. I took probation because I knew nothing about the law. I took probation, I knew nothing about the law. They manipulated the facts. Well, no, they told the truth about the facts on the indictment. But they manipulated the law and said it was aggravated assault by pointing a gun. For 3 years I was on probation, doing good. Mental health probation might not act because I was depressed at the time. I was depressed at the time because I didn't have a job. And I couldn't take care of my kids the way I wanted to. And it was killing me. I was a coward. I was weak around the time because I didn't have the opportunity and the access and research. But after that situation, and I took probation, I was able to get my head together. It ended up getting me a good job. And I was the sole provider in my household, and we was getting good. You understand me? My probation officer, the detective went to talk to my probation officer, trying to see what he can figure out how to violate my probation. You know what my probation officer told him on the paperwork? He's been in compliance for the past 3 years. He pay his fees. He do his community service. He go to work. He don't do drugs. He's been in compliance. I ain't got nothing to give. So you know what he did? He sent his officers because this one foul female that I was dealing with behind my wife's back, and it backfired in my face. She got mad behind some money. Behind some money that she know I had nothing to do. I had nothing to do with. Trying to accuse me and want to go to war with me behind some money. And instead of keeping it in the streets like she claimed she wanted to do, she went and lied to them people and told them I raped her. And then she got somebody else that I knew that I didn't know she knew to lie and said the same thing happened to her, but she didn't want to say I did it because she knew I knew too much. We was too cool. That woman, you can tell how bad she was feeling and how stupid she was feeling, sitting up there testifying about something that didn't happen to her. But she was doing it on account of her friend. She was doing it on account of her friend because her friend knew that she wasn't gonna beat that charge by herself because I could have proved that every time we had sex it was consensual. I could have proved it. Text messages, GPS. I could have proved it. She knew she couldn't do it on her own, so she got somebody else to make it seem like, oh, the situations is identical. If it happened to me, I can't be lying because it happened to her too. Trying to make it seem like she didn't know it. But the girl sat up here on the stand and ended up in me. Yeah, I know her. Oh, you know her. But you told the police report you didn't know me or her. And then you told the police you didn't know me or her. But now in here, when she get on the stand, oh yeah, I know him. We only went on one date. I mean, it was only one time. First we went on one date. Then we only seen each other three times. Everybody, all these people know. They know I didn't do what I initially was in here for, and they know I didn't do the stuff they trying to give me life in prison for. But they hate me so much. The last 3 trials, this man had a white prosecutor. DA Michael Laird, his prosecutors was white. Miss Angela Mann, been his prosecutor. Angela Mann Neely, been his prosecutor for a while now. I've never seen nobody else working with him except Angela Mann and Waylon G. Thompson, both of which are white. But here he is on this trial. He got a black woman working with him to try to defeat the appearance of racism. Like I'm not going to acknowledge that. And then it was somebody in the jury box that was related to her. She probably don't even want to be here. Y'all probably gave her some ridiculous offer to help. And she, okay, all right. That sounds like some good money. Oh, that sounds like a good deal. Oh, cool. That's a good deal. Other than that, I'm not understanding why this man just got up here and lied and said he never had interactions with me. Why he just sit there trying to lie and say I dashed the officer with some feces. While y'all sitting up here blocking my subpoena, I filed a subpoena. 3 years ago, I filed a subpoena. And y'all clerks were telling me on this case, filed a subpoena on this case. And y'all clerks sitting up here telling me that I can't file a subpoena, that they can't subpoena nobody for me because they can't do it for me.
That's not an accurate statement.
That is it's on phone. I can tell you what day it was.
Sorry, sir. I can
tell you what day it was.
Once again, I'm going to tell you when I speak, you must stop, please. That's the rule of law. I know you don't like to follow these things, but that's the rule of law. Subpoenas, if you send subpoenas, first of all, I urge you, have an attorney to help you.
I don't need one.
I know.
I'm a jurist. I'm an expert.
The subpoenas you've submitted are inaccurate, incorrect, and weren't properly filed. That is why they were not submitted. And I urge you, get some help so you can do it properly. That's why, sir. And not everybody can. That's why people go to law school and become
the defendant should have compulsory process and obtaining witnesses.
As long as it's done correctly.
I don't need a paper motion if I ask you on record in the court to do something.
All right. Go to what is relevant. That's enough on that. Go to what's relevant of the allegation of the first-degree felony of aggravated assault. Is there anything else you want to add?
Y'all would have never charged me with this.
Is there anything else you want to add?
If I never filed a habeas corpus, I filed a habeas corpus accusing Joshua Hall, Detective Duchamp, who else? Detective Duchamp, Joshua Hall, Mike Laird, my attorney, of conspiring against me, right? I accused them in a habeas corpus back in 2022, March 9th. Ever since then, I ain't been getting no sleep because y'all want to keep sending people after me in the jailhouse to harass me. And you keep talking about they keeping me in isolation because of my behavior. I was in TDC. I had a job in TDC, doing good. But as soon as I filed a lawsuit, y'all transfer me back down here, throw me directly in isolation. And you trying to talk about my behavior. No, y'all don't have me in isolation because of my behavior. You have me in isolation because of these lawsuits. Matter of fact, I'm about to show the world. You want me to stop? You don't want me to show the world? Hit that button and electrocute me right now.
Sir.
Hit that button and electrocute me right now because the world.
Sir, why don't you act properly, sir?
Oh, I'm acting very properly.
I don't believe anyone in this room thinks that, sir.
I'm pretty sure they don't because they were all handpicked.
No, sir. We're talking about common decency now, sir. The law allows you to speak, but be decent.
Peoples versus Recovery Addict. Now let me show y'all who name is on the front for it. Whenever you sue a judge or the DA or prosecutor, anytime you sue a government.
Sir, once again, you're charged with aggravated assault. Stay within the bounds. It is not relevant.
Depending on this too. In the federal court right now, that y'all real messed up about.
Sir, this is an allegation of striking somebody about the head and body. Stay within that allegation.
I'm supposed to be sitting in this court. I'm supposed to be dealing with this in the Supreme Court because my habeas corpus is pending in the Supreme Court right now.
Anything else?
Because of this charge.
Is there anything else you want to add?
Retaliation through conspiracy, right?
Is there anything else you want to add?
I'm going to continue.
How long do you expect for this to go on?
It's going to take all day.
No, it won't, sir. If it's not going to be relevant to the facts, I will stop this now.
Well, go ahead.
To the facts of the charging instrument, sir.
Do your thing.
Then it ends now. That is enough. It is not relevant anymore.
Retaliation.
That is the end.
So everything I'm talking
Is there
about
anything else you want to add about the allegation?
Habeas corpus in the Supreme Court. Now, I sent an emergency motion, letting them know what y'all keep doing to me, how y'all keep harassing. That Lieutenant Tinker body cam played yesterday. He admitted that he refused to feed me, and he thought that was okay. I wasn't aware of it, so it happened, but I wasn't aware of it, so I'm not giving you. I'm not. And if it happened again,
sir,
I will.
Is there anything else you want to add as to the allegation of aggravated assault in this indictment?
I'm talking about what happened.
No, sir, you're not. You're outside all of that.
And
you said that it was going to go on for days. This was not going to happen. If there's nothing else more relevant to the allegations of this indictment, you have completed your testimony.
No.
Yes, you have, sir. Stay within the four corners.
Y'all called him to the stand because he was relevant to the case, right?
No, you just don't get to give your life story to the end of time. It needs to be what's relevant.
What talking about? This is not a life story.
That is all, sir. You have completed. You are completed, and I told you about she can't take the notes when you are speaking over others. Is there anything else you want to add as to the allegation of aggravated assault? Stay within that.
Yes, it is. It's a lot of.
Stay within that.
All right.
Thank you.
Don't think we've ever seen somebody be zapped before, but we're coming close.
April 22nd, 2021. I was revoked of my.
Hold on, sir. That is 2 years before this event occurred. What does that have to do with what happened on June 6, 2023?
Well, because
please stay within that event.
I'm still in prison. Like this.
Okay, they know that. They know that. Move on to the next thing. I'm sorry. It's the charge of aggravated assault. Just speak on those facts that happened on or about June 6, 2023, not what happened 2 years or 3 years before in another case. Thank you, sir. Stay within those rules.
It's not retaliation. If you relate, the law say if it's directly related, then
stay within what happened on June 6th, sir.
All right, let me go about this. Let me see.
If he were a little more educated, I think he could make an argument. When I say educated, I'm talking about legally. he could make an argument that might allow him to stray into this area. If he's saying my defense is that this is a false allegation and this is why, this is the evidence I have, he may be able to get there, especially considering the court let a lot of this testimony in during the state's case. Yes, some of it was on cross, but they let it go. So he might be able to have a
Federal Statute 18 USC 1513 subsection E. Whoever knowingly with intent to retaliate take any action harmful to any person for providing to a law enforcement any truthful information relating to the commission of any federal offense shall not be imprisoned more than 10 years or a fine or both. That is a federal offense to take any action out of retaliation for providing to a law enforcement any truthful information. Every trial I've been to, I told the truth. I only open my mouth if it's backed up by witnesses or the record. That's the only time I open my mouth. Whoever calls or induce any person, this is Federal Statute 18 USC 1512 subsection B2A. Whoever causes or induce any person to withhold testimony or other object from an official proceeding shall not be imprisoned more than 20 years.
All right, hold on. Again, that is not relevant to this case at all. This is a state jurisdiction case, not a United States jurisdiction. There's the federal government. It has its own sets of rules, ladies and gentlemen. I was a United States attorney for 20 years. And this is state law that we're dealing with here. Distinct laws. Distinct law.
Focus on.
Sir, let me complete the instruction of law to the jury. Please, once again, for the 100th time, don't interrupt when the court's giving the law. Thank you. That is not relevant to what the charge is in this case. This is a state jurisdiction case with its own elements. We're not trying a federal crime right here in this court. That's for the United States district courts, for the United States attorneys to handle. This is state law. It has its own independent set of laws, and this is what we're dealing with, this state law of Texas in this allegation under section 22.02 subpart B, subpart 2, subpart B of the Texas Penal Code. That's distinct from federal law, and your statements on federal law are not related to the relevance in this case. Please confine your statements that you've been allowed to give here within the four corners of this state law brought crime. Thank you for following the law as instructed.
Yes, Ron.
Go ahead.
Mention is the state part, right?
Look at the bailiff.
If two or more conspire to injure, oppress, or intimidate any person in any state on account of any right or for exercising the same, shall not be in prison.
What are you reading from, sir?
This is federal statute.
That is, once again, its own set of rules. This is not what we are. We're not a federal court.
USC.
I know. 20 years I dealt with that, and I dealt with the most serious offense in the United States that was committed. So
what was that?
We are dealing with state law, not the federal law. This is a state law matter, and what you're reading is outside the relevance in this case, and you are denied to be allowed to do that. You can put it on the record later outside the presence of the jury. It's not related to what this jury is going to be deliberating on, and it's the state law violation of aggravated assault. Please stay within the directions of the court and the law. Thank you for doing that. Move forward, please.
Okay. Why do y'all hate me so much?
Anything else you want to add, sir? anything you want to add relevant to the case facts?
Yes.
And the law as it's supposed to be followed? Thank you.
Yes. So Lieutenant Ford, right? Let me tell you about the Lieutenant Ford real quick. So when he 24, when he first wrote this is the first page of his report. Outside of the one yesterday, the one we were looking at on the second page. This is the first page. Everybody else report identifies every officer that was there, right? But Lieutenant Ford's report only identified Purdy and Hebert. They wasn't even there. Right. Officer Stevens' report identified everybody that was there. Officer Syndergaard report identified everybody that was there. Officer Darby report identified everybody that was there. Sergeant Anderson's report referenced nobody at all. Lieutenant Ford report only referenced the lady that got these guys to jump me 4.5 years ago and knock my teeth out and reconstruct my teeth the way it is. After she divulged my charges to the dorm and told the people I was a baby rape. And of course they don't believe me because she's an officer. So I wrote a grievance on her and I got 10 people that was in the dorm before I got jumped. Before they knocked my teeth out, I got 10 people to witness what she did. You know what the grievance officer told me? You have no evidence. It's your word against hers and then vice versa. This is not a grievance. Right after that, I got jumped. My teeth got knocked out. Captain Lewis and Captain Miller had to come take pictures of me. I woke up with blood everywhere. I woke up with blood all over my face, all over my clothes. Ever since then, that woman been constantly harassing me. She been constantly harassing me. Now, lately, she been messing with my food. I had to put myself on Johnny set because her and Lieutenant Ford teamed up to convince everybody else all the lies that they've been telling people. So Lieutenant Ford, you know, that was Syndergaard. I forgot to ask him that. Officer Syndergaard, he referred me to Lieutenant Ford. Before me and Lieutenant Ford had any type of problems with each other, he referred me to Lieutenant Ford as a trustee in fact. Him, Biggers, Officer Jones, what else was that? Officer Jones, Biggers, Officer Washington, the guy who works. Listen, I gave nobody problems in the gym. But as soon as I started filing paperwork trying to go home, that's all I was doing. I wasn't trying to get no money from the state. I wasn't trying to get no money from the government. I don't care whatever mistake y'all made. I don't care how much y'all like me. I don't care what type of crimes y'all committed to get me here. I just want to go home. We had this up. I sent the affidavit. I gave an affidavit to Sergeant Carter and told him to give this to Detective Gardner, Lieutenant Ford, and Sergeant Anderson. That affidavit let them know I swear I will testify to this affidavit. I won't file a lawsuit on nobody. None of y'all. Just dismiss the charge so I can go home. You know what they did? Carter came back, hey man. Hey, I had got a notarized and everything. I told him, next time we go over here, I'm gonna testify to that. They spit in my face. It's in the state. It's in state hand now. We ain't got nothing to do with it. So y'all not even gonna go tell the people that I just want to go home. You know, look, it's about arguing. Really? So y'all just want to? You gonna keep me here? All right. Let me forget it. Let me see if the lawsuit's worth. Now here we live. 5 months after I filed a lawsuit on a judge for refusing to issue the writ of my habeas corpus, after my attorney admitted to refusing to give me the search warrants, refusing to give me the search warrants to my DNA, my phone, and my car.
Judge is taking the phone
He admitted. He admitted.
Hello.
He admitted.
Oh, yeah.
I mean, yeah, I didn't give it to him because he wasn't supposed to ask. I was found not guilty. They charged me with 3 aggravated sexual assaults altogether. I was found not guilty at their first trial. My lawyer told me, you get found guilty, not guilty at this trial, they don't dismiss the other 2, you go home. Just don't testify. I got you. I'm like, all right, cool. I say, man, make sure you ask her this. All right. I say, man, what you doing? Ask her the question. I'm going to. He kept on trying to divert the attention the other way, and I had to argue with him at the table just for him to ask her the questions that man, if you don't know this man, how was y'all getting in contact? How is his number in your phone? Under the text-free app? Well, who told you to download the text-free app? My boyfriend. Call his boyfriend to the table. Sir, did you tell your boyfriend to download the text-free app? No. What about the birthmark that's on your hip? If I don't know you, we ain't never had consensual sex. What about the birthmark? But because you said this happened in the dark. No one ain't see the man's face or nothing. You said this happened in the dark. How could he see a birthmark on your hip if he couldn't see you? He found not guilty of that. They stopped letting me come to court periods for about 2 years. And midst of that, charged me with this. Why is Lieutenant Ford all of a sudden coming harassing me like I did something to him? Why? I hated that man because he kept on. Dude next door squirted waste in my tail because I wasn't selling him a pack of cookies. I'm talking about, and yes, like Lieutenant Ford, it was waste everywhere. I'm not about to put it in my own cell. Ford, bro, this retarded, stupid dude. Listen, Levine won't clean out my cell, man. Can you please make Levine clean out my cell and let me go in there and take a shower? Or look, matter of fact, just give me some of that bleach and give me a towel and I'll clean out myself. Man, I ain't trying to die, man. This Corona was serious. It was 2022. Corona was serious, still serious. You know what he did? You need to stop arguing with people. You need to stop arguing with people, grievous, man. Wave his hand. Walk off. My heart must have dropped. So you gonna leave me in this? You gonna leave me sitting in another man's waist? Trustee, come through. Trustee, bro, listen. Slide me the mop real quick, bro. Let me get that bleach right there, bro. Just slide me. Yeah, I ain't getting it in. Bro, just give me this mop and okay? Listen, I ain't getting that. You're about to make you lose my job. So I dashed him with water. Water. He go tell Lieutenant Ford. You know, cuff up. Cuff up. So you're not gonna let me explain why I dashed him? I don't care. Cuff up and explain to me when I take you to your isolation tip. What? You gonna put me in isolation for dashing an inmate? But you gonna leave me sitting in this? No. You're not about to punish me. No, why are you doing that, man? You're not about to punish me for dashing an inmate for refusing to give me some chemicals to clean up this waste that you refuse to make the CO do. You're not about to do that. Because I ain't never did nothing to you. That man can't ask me, did you want to be a trustee? I'm like, yeah, man, I've been trying to be a trustee. Whatever. Come to find out, he only asked me that because Biggers referred me as a trustee. I'm like, oh, that's why he can. Because Biggers let me know, yeah, man. I told him, man, only person back here competent to be a trustee. You know what I'm saying? You don't give me no problem.
The courtroom stacked with
Why
bailiffs.
he ain't named trustee yet? Because he can't ask me. You know what I'm saying? All right, don't worry about it. Then next thing I know, I had this little situation with the dude squirting away from myself. He ready to ride down on.
That was
Ricky. He ain't trying to do no talking, cuff up, or I'm coming there and get you. What? Really? You ain't gonna clean up this waste, but you gonna come in here? Or you gonna come in here to hurt me, but you ain't gonna clean up? All right. Come on, let's fight me. Because I'm not cuffing up. Now, I'm not about to cuff up for you to hurt. Now, I cuff up for you to clean this white cell out, and then you can write me up if you want me to, and block my privileges. But you're not about to come in here and put me in an isolation cell after refusing to clean out this net. So then, Lieutenant Ford, after he do all that, after he run down on me, after I get done dashing him with the water, not waste. Even then, even him leaving me and somebody else waste, I still didn't have the mentality to stick my hand in the toilet being in another man's waste I was throwing up. So I can't touch my own, let's hold somebody else's. I'm in there gagging because he don't want to clean the cell out. So yes, I started dashing him too because he wanted to punish me. Yeah.
He just confessed.
He get me to the isolation cell, right? But man, this day I didn't swing at nobody. I didn't threaten to stab nobody. You know what I'm saying? He get me to the isolation cell. I had all my paperwork, all my legal work, my legal books, my kids' pictures I would never get back. Pictures I would never get back. He threw all my stuff. He threw all my stuff away. He threw all my paperwork away. All my books that my sister bought me, all my legal books. My checks cold. I couldn't even file a motion with the Supreme Court. My prisoner discharge motion with the Texas Supreme Court of Criminal Appeals because he had to throw all my stuff away. You know what I'm saying? I wrote a grievance about it. For my whole month, I'm steady begging my stuff back. I'm letting them know, look, man, I'm sorry, I will give y'all no problem, man. I clean this stuff up with some jail soap next time. I ain't tripping. Just give my stuff back. I'm begging for I never seen my stuff again. He threw all my stuff away. Or he gave it away. One of the two. I don't know. It's a lot. You know what I'm saying? I keep a lot. I had a lot of paperwork. I keep a lot of paperwork because I'm always either writing my kids, studying the law, I'm taking notes, doing what I need to get back to my kids. Throw it all away. I'm like, all right, cool. So I see what type of time you on. You know what I'm saying? You trying to shield me, and you trying to keep me in prison. Okay, cool. Let me stay out this man's way. He ain't playing no game. Let me stay out this man's way. He came back a couple months later, came back to that same cell we put me in. Hey, you want to move the indoor? No, I don't. I'm not leaving out this cell. Because this cell I'm protected in. It's a camera right there. It can see everything. I'm not leaving out this cell. You're like, what about indoor? Now, man, this is Lieutenant Ford I'm talking about. What about indoor? You want to move to indoor? No, I'm good. I'm not leaving the isolation cell. I'm protected. Can't nobody throw no waste in my cell. Nothing. You can't take my paperwork without it being seen. Nothing. Right? But then he had somebody else try to come. He had a couple other people trying to convince me to leave the cell because he needed it. Oh, I don't care what you need. I need this cell. You go home. I need this cell. I'm not about to put myself in a situation where somebody else can do what you did. turn around. This man back door, wake me up. Hey man, we gotta do maintenance in the cell. So pack your stuff and move in the ISO 1. Mind you, I was going to the day room. When I go to the day room, they let me go to the run day room, right? Because I don't cause problems. All the other inmates back there, they gotta cuff up and go to the day room out back in isolation. In isolation, you gotta keep the cuffs on. But because I never gave the officers problems, they will always let me go to the day room on the run, put me in the cage, take my cuffs off, so I can take me a shower, so I can do my legal work, so I can talk on the phone when I want. You know what I'm saying? You can't do that in the isolation hallway like that. You know what I'm saying? You can't watch TV like you want in the isolation hallway. They let me go to the run, so every time I go to the run, I gotta pass up all the cells, right? On my way to the run, the day room the night before, it was a mentally deficient dude. He really had a real bad mental illness. He played with his waist all the time.
Mr. Peoples, hold on. Do you have much more to go on? Because it's into the lunch hour. This jury has been in here for a long time. Do you have much more to say?
You say talk about the case. I'm telling you.
Do you have much more to say is the question.
Yes.
Then we're going to break for lunch. Can all of you return back at 2:00, ladies and gentlemen? 2:00. Thank you. Please remember the instructions the court has given to you. Thank you.
Judge has been incredibly patient. He's telling his story. Obviously, this is from his perspective, but he feels justified in things that he's confessed to, which are crimes. And the law is the law. You can't take matters into your own hands.
We're in recess.
We're in recess. Recess has begun. All right. Wow. I think we get an hour. Does that sound right? Come back at 52 minutes from now. This will be part 5, right? I think it's part 5. The crappy trial you didn't know you needed. It's right here. We've got it all for you. We'll be back with Judge Stevens after the lunch hour. He did, as he was getting into the fecal matter, figuratively and literally speaking, the judge said, let's stop right there. The jury may still have an appetite before you get into that next that next matter. And we'll call it a break for right now. We'll be back shortly. Is there a thumbnail for this? Is there a thumbnail? Yes, there's a thumbnail. We will show you the new thumbnail here in just a second. Actually, let's see if I can do that. We're a portal to the new thumbnail. How about that? Customization, redirect. There we go. New thumbnail is up. Let me just fix it to be the latest version. At least the version I have that's the latest. Change. Thanks for all the likes today. Appreciate it. We're showing 253, which you can't see because I've got poor lighting. There you go. 253 on the likes counter. Make sure your like gets counted. You don't want to miss that. So click the like button if you haven't before, and it will show up here in just a matter of seconds. All right, we're all set up. We have the new thumbnail. We have the portal connected. We've all still got a little bit of appetite left. I would not eat a heavy lunch today. Maybe a light lunch would be the way to go on this one. You never know, how testimony is going to go. As the judge said in his own words, let's see what happens next. Let's see what happens next. Oh, what Stream Deck? It's the Stream Deck XL. It's got like 1, 2, 3, 4, 5, 6, 7, 8 by 4. So that many buttons. I don't think he's going to cross him. I think he's going to sit down and say, we rest our case. That's my thought anyway. See you on the flip side. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in 49 minutes. 49 minutes we'll be live as we continue the show. Judge Stevens, and it's been a wild one today. This might be one you might have to rewatch. We've dialed back the jokes. We told all the jokes yesterday. That's the thing. We don't have any more poop jokes for chat, so we're dialing it back today. I'll be back for this one, says Old Time Gamer. See you guys after lunch. Britta, good to have you here. Welcome. Man, verdict today? I think so. We'll see how long his testimony takes and how long the judge allows it. I'm worried that if the judge tries to physically remove him from the stand, he's going to do what we've seen him do on video twice before. And that's when it really hits the fan. You guys, have a good break. We'll see you in just a little bit. Bye-bye.